hammer.
We got news on.
Call the meeting to order. This is the April 8th, 2010 meeting of the Goffstown Planning Board. I welcome everybody here. I especially want to welcome as the new chairman, Brian Rose, our new planning director for the town of Goffstown, who's sitting here tonight quietly. We told him that we wouldn't put him on the spot for the first evening only. And we welcome him and his capabilities to the community, and we look forward to working closely with Brian in the future. Welcome, Brian.
Thank you, Mr.
Would you like to say a couple words of introduction? You're on TV. It's free.
I'll just say that I'm excited to be here and excited to be working with you all, and hope that I can make a difference in Goffstown planning and in the lives and the citizens that live here as well. So I'm excited to be here. Thank you.
Welcome again, Brian. Normally we take up a few things of correspondence before the meeting officially starts at 7:15. We'll look at the minutes of March 25th, 2010. Are there any corrections which the members of the board wish to bring forward at this time?
Mr. Chair,
Yes.
I'd like to make a motion, we postpone voting on these, cause we just got them, and I haven't even had a chance to read them yet.
They got an email to us, didn't they? Yeah.
I don't get email, I get a paper mail. I didn't get a chance to read them.
All right.
Take them up later on in the evening, 8:30 break, it's quiz time.
Oh, I was so proud of you for going till 9:30 without a break last meeting. You did such a good job.
I know, but do fiefdom.
Oh.
Under action items, I don't think we can take that up quite yet on the,
And I'll
how
read
about the village salon? Anybody got any comments, concerns, otherwise as to the correspondence sent to us by the planning director, reference to the change from an insurance agency to a salon spa at 10 Elm Street. Used to be Draper Insurance. Anybody have any concerns with that change?
Nope.
tonight.
In reflection of this, does anybody from the board care to make a motion that we agree with the conclusions of our planning director?
Do we need to? It's actually was a determination by Derek Horn, wasn't it?
Yes.
Yeah, it was a zoning determination.
So there's no comment?
No comment. I don't have
No
any.
comment from members of the board.
No comment.
You'll be seeing probably the sign request at the next meeting.
So that
Okay.
we'll
It's in
vote
the
on.
village commercial district, just the sign request.
Okay.
We also have a piece of correspondence, which I'm assuming from our chair of the Conservation Commission, relative to timber cutting on the King Trust open space subdivision, and we'll pick that up and add it into the record when we discuss that in a few minutes, Kimberly.
Sure.
Does any other member of the board have something to wish to bring to our attention this evening prior to our opening session of public hearings? Barbara, anything? Kim? Good evening.
Motion to find people who come late.
Later.
Well, actually, Patty, were these noticed for 7 or 7:15?
The meeting starts at 7. The
So-
hearings start at 7:15.
So we have a few moments.
And the forestry management plan is a correspondence item.
Right, so we can take that up right now, right? Okay.
Then let's move forward into the forest management plan of the was it Anna King Trust, Joy Open Space Subdivision, map 3 lot 28. Is there somebody here wishing to present in reference to that particular concern? Attorney
Hi,
Doyle.
yeah, Richard Joyle, I'm the one who sent in the letter, and I have with me John Stout, who is the logger, and we submitted a notice, basically, of what we wanted to do, what we're gonna clean up the mess from our most recent little natural disaster. I understood from conversations that the Conservation Commission had opposed this. I don't know if it's true, I don't know what the basis of it is. I was here anticipating that might need to be addressed, and I addressed that in my correspondence to the town. I didn't direct it directly to the planning board. Attached to the letter was the actual proposal, which essentially parallels what the county forester had suggested was appropriate to be done in a similar report that was attached to John Stout's application to proceed with cleaning it up and taking the valuable timber that's on the ground off the property. I don't have anything to embellish beyond what I've said. I think the report and plan is self-explanatory, but if you have a question, I'll be glad to try to answer them, and if I can't, I think John probably can.
Brian, is there any additional information that you have obtained or seen that is not reflected in our package that we received?
No, not today.
Members of the board,
So I guess I wanna hear from the Conservation Commission.
any other members of the board wishing to speak? Or open it to the commissions and the public?
Speak afterwards.
Any commission member wishing to speak? Kimberly?
Kimberly Pease, I'm Chair of the Conservation Commission. This came to us at our March meeting, and it was just sort of a notice that they were going to, intending to cut, in the open space conservation area. So we did a little research with Derek and with Steve, and maybe Brian's been involved. When that easement was recorded, it was noted in the sub-conditions that they needed to have a forest management plan, and that cut plan had to be approved by the board before they could continue to harvest timber from the open space area. As we all know, this is a bit of a controversial place because it was timbered in the process of being permitted for development. But one of the big concerns that has come out of this, we did actually schedule a site walk, and then it poured down rain, and we said, okay, we're not gonna go out there and look at it now. But in the process of that, I believe the timber cut was sent north to DES, and I've received phone calls from DES and EPA this week saying that they have concerns about this. Their concerns are that there's not a forest management plan, and for those of you that don't remember, and I wish perhaps Mr. Joyle has a better map, but there are extensive vernal pools out there, and this is the magic time for you to be a vernal pool creature, to run around and do all your vernal pool activities. And there are large vernal pools up there, and the buffer that was placed in the permit conditions is a 100-foot buffer. And EPA and DES have concerns that in lack of a formal plan, that any tree removal is going to affect those vernal pools. And so I believe we'll get more correspondence from them, but the basic issue, and I understand Mr. Joyle's concern that the trees have broken, or that some have fallen over. And if in fact they do what they claim, which is that according to, the way I read the letter, is that the trees that are broken or have fallen over will be removed. Conservation doesn't have a problem with that, except for those that are within the vernal pools and the buffers. And because these are so big, I don't know if you remember, but the buffers kind of overlap each other. And I haven't had a chance to site walk it, but, DES and EPA both had very concerned that they leave those that have fallen into the buffers and into the vernal pools. Those have an ecological value, so despite the fact that Mr. Joyle is looking at them as a timber resource, they need to be left in place, as well as the fact that if they choose choose to remove anything that's fallen over, they have to do so very carefully to stay out of the buffers and not alter them. And especially right now, I mean, anything that goes on in this month has, you know, just a huge effect on the organisms that are moving and breeding and reproducing right, you know, now. So, I mean, it's bad timing for the storm, it's bad timing for them to be pulling things out. Conservation's concerned that we haven't seen a formal forest or timber management plan, and in lieu of this, they asked the forester to submit the letter. I don't know how you feel about that. Conservation is concerned that that's not technically a plan. If they choose to just remove the downed timber, broken timber, and they stay out of the vernal pools and out of the buffers, they have a right to remove those trees, but the question remains, how are they gonna access those areas? How are they gonna stay out of the buffers? They almost all overlap most of the property, so those are our concerns, so.
Thank you. Does Public Works have any weighed in on this at all?
I wasn't aware of any of this till
Okay.
tonight, sorry.
Any members of the public wishing to speak in reference to this action? For or against, makes no difference. Back to the board.
The question is this before us because they want to do removal of trees without there being a forest management plan, so therefore it has to come before us? Is that procedurally why it's here?
I think the question might be, what is a forest management plan? Is it a physical plan, like a site plan that shows where they're working? Or is it a physical written document plan that tells how they're gonna do it and the cautions they're gonna take and how they're going to, make sure that they're working outside of the 100-foot setbacks and that they qualify how their cutting is being done? That's what I get the gist to be from Kimberly. How do we,
Well, the question, what is this board's jurisdiction, if I recall, is because the condition on the approval was we required a forest management plan for there to be any cutting.
Correct.
Solely from memory, and there is none presently, but for this, what I'll call a forest salvage plan. So the question is, are we going to accept this for purposes of satisfying the condition of our approval, or what conditions would we put on it? Is that where we are procedurally?
yes. Patty?
And just some background, when Mr. Joyle came in with his, with the UNH cooperative and along with the plan, the written plan from Mr. Joyle, Steve deemed that as, he took that as was a management plan, a forestry management plan. That's why you got the letter from Steve. So that, if he accepted the plan that was presented in the written form from Mr. Joyle. But it's still, whether you determine that this is adequate enough or you want more.
Phil, any comments?
Well, I have one question at this point, and I might have some more. On the letter from Steve on B, they talk about the, and I assume that this is taken from what's in the approval on the site plan, that it talks about the activity adjacent to or in or around so-called vernal pools. And I guess, is there a certain time of the year when you could do work in or around the vernal pool?
Not as a permit condition. As the condition of this permit, it states that there's a 100-foot buffer, permanent no-cut buffer around the vernal pools.
Well, but I guess that's not my question. My question is, there's certain times of the year that the vernal pools are active, or there's certain times of the year that the pools are not perhaps active, and that it is possible to, for lack of a better term, slightly infringe on the vernal pools to achieve the removal of the trees. I guess that's my question.
I think what, I know Mr. Doyle would like to speak, but I thought I heard them say that they had no intention of entering the vernal pools nor the buffers to do any of this timber cutting this.
I didn't hear buffers, I heard vernal pools.
There's a couple of foundational points I think have to be clarified. Number one is, there is
For the
no
record?
intention to do any cutting. We're not going in there to cut trees. We have photographs to show those board members who may not have had an opportunity either to have driven by the property and have seen what is lying along the sides of the road at Shirley Hill, what's interfering with the Woods Road behind the house, which is actually a dangerous situation, and the piles of trees that are lying on top of one another in the areas that were accessed last year when there was some cutting. Our plan has no intention of cutting. I wanted to mention though, that apparently certain trespassers have been going in there with chainsaws and have been cutting up the trees that are on the ground in order to assist them in their access and use of the property, and that includes areas that we wouldn't have affected that are near some of the vernal pools. Part of the plan that was presented here to you tonight specifically says that we have no intention of affecting the vernal pools. If there is a dangerous tree that is nearby that is lying or sprung, it needs to be pulled away so that that hazard no longer exists. And for purposes of liability, this is kind of important. We have to get it out of the way or make it safe. There is a couple of trees that are affecting the vernal pools, but as you can see in the plan, and as was recommended by the county forester, we're not gonna touch those. This really isn't an intention to go in there and do anything except clean up what is a mess and what is a danger, and what is in the way along the side of Shirley Hill Road. And those pictures probably speak better than I can, and I'd like to pass them around if I could. John took these for us, and for me. The other assumption, I think, is that this is forestry management. I have to respectfully disagree with that characterization. If a tree fell on the garage, or it fell on electric lines, or it fell anywhere in and around the house, which some of these trees have, I don't think we'd be arguing that it's part of a forestry plan in order to clean it up. And so I respectfully dispute that characterization. As a consequence of that difference of opinion, I don't think we even need a plan. I don't think we really needed to ask the board, because this doesn't affect the subdivision of this property at all, or the plan that was conditionally approved under it. Some of you may strongly disagree with me, but I sincerely think that the subdivision plan has nothing to do with what we're asking to do, and that's to clean up a mess, a danger, as well as an impediment to accessing certain parts of the property. The plan says we're not gonna touch the vernal pools. I didn't even wanna have to deal with this. This is an expensive process. In order to pay for that expense, the logger will use what he takes out of that in order to underwrite the cost of what otherwise would come out of the pocket of the estate. The estate isn't interested in spending money to do this job because it's an expensive operation. The compromise was to have the logger go in and take what he could salvage from the property and sell it in order to underwrite the cost. Not sure if any of you what those pictures depict. Some of them depict the road. Some of them depict obviously the house in close proximity to something. Some of them are out there. But will be man, this subdivision ever
question, Attorney Doyle. I mean, I know, for example, I haven't looked at the pictures yet, there's a big tree that's been literally uprooted on the Shirley Hill side. Okay, okay.
You'll see the photograph.
Are the vernal pools, and I guess I'm looking at Attorney Doyle and Kimberly for this, are the vernal pools, to my recollection, were at the back end of the property, not along Shirley Hill Road,
Right,
right?
they're up in the.
Behind the house in the back, the crest in the
open
back.
space, which is in the north, northeast, and east side of the property.
So when you talk about the fact that you're not going into the vernal pools, and I guess I'm looking at
You'll see
Mr.
a vernal
Stout
pool
here.
depicted actually, one of those,
And, you know, the first thing I'm looking at is one with a tree down. You know, I can hear from a Conservation Commission standpoint that that down tree by the vernal pool has value to the vernal pool, so from their perspective, it's in the buffer, it doesn't come out. I'm presuming that there's a disagreement.
I don't think there really is, we don't want it,
All right, so is the cutting and removal that you're talking about doing outside of the vernal pool and buffer area?
correct. I can't tell you exactly. Entirely within.
I
Certain
yeah.
sections.
Kim?
No, not even a bench.
There you go. Kim?
I have a question for Mr. Stout. Will you be considering, collateral damage by waiting until the ground dries out some more, rather than, because the ground is so wet right now?
Yeah.
So are you considering waiting a little bit until
yeah.
you won't have quite so many ruts and mess created by the equipment that's gonna be in there? Well, that would be a concern I have.
So in regards to that, if we agree there's not an issue with this, whether you need permission or not, when are you looking at doing this activity? Because I want to hear from Kimberly about what all the little vernal pool living thingies are doing. So you're not talking about a significant period of time for
No, I
land
think
drying
it's short.
Okay. So, would the applicant be willing to consider a requirement by the board that it not be done before a certain date? That, I mean, you know, the trees are not gonna be damaged from a market standpoint in the next month or two. On the other hand, it's not the planning board's obligation to ensure that, I mean, you need to preserve your assets, but.
Well-
All right.
Follow up?
Yes, Tim?
Well, then, would you be willing to state for the record that if there are significant damage to the grounds, that you would make some sort of repairs to the skidder trails and such, so that we wouldn't end up with rivers that'll be flowing in skidder trails and such?
Well, after the first time, if there wasn't any damage, I'm gonna continue to do the same job, if not better.
Okay?
No issue with that.
I'm just concerned that, you know, with the ground being as wet it is, that a month from now, you'll drive across the ground, presumably it wouldn't be as bad as it would if you did it next week.
Oh, yeah.
Okay.
There's more rain and you wait longer.
Okay.
Obviously, the water's
I'm just looking for something from you that you're gonna make sure that things are smoothed up and cleaned up when you're done, and,
oh, yeah, it's not, it wasn't like it was before.
okay, thank you.
Carl? Any comments or questions? Thank you, Phil. Anything else? Brian? Any comments, questions?
Just reiterate that it does state that the planning department or the planner recommends approval of this forest management plan, so.
Based upon the discussion, Kimberly, do you have anything that you'd like to add to the conversation, presentation?
Well, I guess I just, I think that we will see continued documentation from EPA, regarding this. Mr. Doyle's correct, the subdivision plan is not finalized. However, there are permits that have been issued, right? You got your wetland permit? Yeah. The permitting agencies are very concerned. This is an extremely unique habitat. There are vernal pools up there. I disagree with Mr. Joyle and Mr. Stout by saying that they cannot keep out of the vernal pools, because the vernal pools were mapped. They are on maps. You can go to where they are, you can step 100 feet back, you can say whatever's there, stay out of it. And I think that that needs to be reminded to them, that this is ecologically the most important time of the year for these organisms. They are incredibly unique habitats, and that they need to stay out of the vernal pools and the 100-foot buffer. And it concerns me that we have a logger saying, or an owner saying, well, we can't really do that, we don't know where they are, the trees have fallen down. Well, that's their role, that's their job. These areas are indeed mapped, and it is indeed possible to stay out of the vernal pools and the buffers. The trees, when he speaks about the trees being a danger, I'm not sure what the danger is. If it's open space and they're vernal pools and they're protected, if the tree's leaning against the vernal pool, that's not really a dangerous situation, that's a habitat. So I disagree on those regards.
Thank you. I'm gonna ask for an opinion here. We approved this project with conditions. And one of those conditions was if any forestry, and I would assume that goes back to our approval date, not the fact that they've enacted or recorded any documents or completed the process for the conditional approval, that the conditions that we attach to that approval commence on the date of approval. Am I wrong in that assumption?
Position I'm gonna take.
Okay.
You can't elect when
Yeah, when it's, so that,
convenient for them.
so basically have an approval of the date of the action taken by the board, and those conditions are enacted upon at that, commence on that date?
Right, you just can't sell lots until the conditions are approved in the plan. And any restrictions on use of the property on the date of conditional approval. I don't know which one of us you're looking at, but I'm gonna answer it.
Then, if in fact it's our jurisdiction to approve a forestry plan, forest management plan, as proposed, assuming that we can add conditions to it, to our approval, that requires some compliance factors, but it might be a reiteration of what work gets done in adjacent to the buffers, whatever. Yes, Barbara?
I think we're talking about two different things. And apparently Steve Griffin might have disagreed with me, but there's a forest management plan, and quite honestly, I don't see anything in front of me that looks like a forest management plan. And there's a plan for cleanup and removal of storm damaged trees, which is what I think we're really talking about here. So, I don't, I have no desire to drag the applicant through whether or not we like this forest management plan or not, because we're not really talking about that. We're talking about trees that are down or broken as a result of a storm that occurred, and when and where he can remove the trees. I mean, so from what I see, you're looking at the plan for cleanup and removal of storm damaged trees as submitted with the declarations and a plan of action. And a great deal of those trees do appear to be by the house on sort of the upland side of it. And it does, who knows who did the cutting, but I do know people are on that property all the time, so the applicant's representation that other people are in there cutting for trail access is believable. I mean, it seems to me,
We close the public hearing? Oh, we haven't, there's still a discussion of board
no,
members.
it's still, all I'm saying is that when I look at the plan of action, what we seem to be talking about is the second to the last line that says down trees will not, and I think it's supposed to be, will not be removed from the vernal pool areas. I think that's what Attorney Doyle was saying, they weren't going to remove them. So I think we're talking about whether we want, I don't know whether the board members have problems with them clearing trees that are clearly down from those pictures, but it seems to me the issue is what activity goes in around the vernal pool and the buffer area.
Correct.
So, I think that's what we're talking about.
Give the presenter one last go at us.
Concerned about the representation. Ron, well, negative response. Don't know what's going on behind the scenes. No one is telling us what's happening. And again, we're not looking to create or embroil ourselves in issues that we address have a problem. We're trying to avoid that. That's why we came to tell you what we were doing openly in advance. Again, we don't have a need, a desire, or purpose of cutting trees at all or affecting the vernal pool negatively at all for the same good reasons that we would like to discover the vernal pools. I'm discussing them more clearly. All we want to do is clean up the story.
Thank you. Any other public comments or questions? Close the public hearing. Board members, do you want to discuss this now or later?
I think people are here, we ought to do it now.
Okay,
Well, we've got other
move it
things.
forward then, please. Jim?
I will comment and then I'll make a motion. One, I don't like to be threatened by applicants. And if letters threatens the town with liability, I'm inclined to say, we'll just deny it and call this bluff. I don't like that tone, and I don't want to hear it again from this applicant. On the other hand, we saw last time at the last hearing that our code enforcement tends not to enforce any restrictions on land use activities. So maybe, what's the point of our doing anything? We'll just get away with it. Those are the two sides of my analysis. I'm unhappy with both the applicant, in this case, for the tone of his presentation in writing and the town's activities. I would make a motion that we approve this. And third, if you look at the conditions that are in Steve's report, or I'll depersonalize it, because Steve's saying about the planning coordinator, the terms, the restrictions are pretty restrictive. It's removal of vegetation. Down trees is still vegetation. And I think he is required to come back before us, and that was a condition of approval. But I understand the desirability of removing the down trees, but we have a concern about the vernal pools and the buffer. So I'd make a motion that we approve this plan, but not as an interim plan solely for the purposes stated in it, but not any removal within the vernal pools or the vernal pool buffers.
Anyone second the motion?
Second Jim's motion.
Any discussion or amendments to the motion?
Is it intended by the term removal that there be no activity in that area?
Yeah. Yeah, nice, thank you for the the correction. Let me add, I think if it later is concluded that that can be done within the vernal pool buffer and Conservation Commission, whoever agrees, because we're beyond the season, can come back, but right now, I'm not hearing that. This is a sensitive time, and he plans to proceed fairly quickly.
You wanna make it part of the motion that the coordination of the work should be done through the Conservation Commission in terms of policing, in terms of
I'm not sure that.
making sure that it's done accurately and outside of the buffer zone?
No, I think as with any activity, it's subject to being supervised, and I don't think it's fair to turn the Conservation Commission into a monitoring organization unless it wants to.
Just
We
leave
have
it
town,
open to supervision
we have
by-
town, yeah, but we have town staff that should be doing that.
Tim?
Jim, your motion is based on an assumption that the applicant and their crew that's gonna do the work are acutely aware of where the vernal pools are and the boundaries and the buffering themselves, and I don't know how we can know where that is. I mean, they may have been flagged once, but I don't know if those markers are still there or
If
not.
indeed it's 100 feet from a vernal pool, that's not a difficult measure to make even in the field, I don't think, by
As long as
anybody.
they're-
Experienced typical logger would have a sense. He measures height of trees all the time by eyeballing. That can be done.
In this sense, most of those vernal pools are wet, so they're very visible. There's not a lot of green on the ground, so easily seeing where they are. And assume that somebody with open eyes would be able to facilitate that.
And I'll note the applicant or his representative they'll be doing this with appropriate care and diligence and attentiveness to the impact. Since they've made that as a representation, we don't need to make it as a further conditions. That's part of their representation. I wanna make sure the minutes reflect that, though. Yeah.
Any other board members wish to comment, modify, or propose an amendment to the motion? I'll call a vote. All those in favor?
Aye.
Say aye. Those opposed? Motion carries. Chairman votes yes. Let's go back to our regular scheduled items under old business. Map 5, Lot 102 and 103, public hearing, meeting for a time extension request for the approved application of a 34-lot open space subdivision with one open space lot, Holisol LLC applicant, Worthley Hill Road, zone residential 1 and agricultural. Do we have a representative for presentation?
Good evening, Mr. Chairman, members of the board, Mr. Rose. My name is Attorney Panciaco, and I'm here to follow up with the board on the remaining outstanding conditions on the project owned by Holisol LLC on Worthley Hill Road. The project, as the board knows, was approved in May of 2008, and we were last before the board in October of 2009. At that time, a time extension request was granted, subject to a number of conditions. There were other conditions that were outstanding that needed to be taken care of, and I'm here to provide the board the update. And starting with the conditions on the time extension request, I can go through them one by one.
Please.
First condition was that a report be provided regarding the water supply issues. The state permit for the water system has been approved. A tri-party agreement, and I have copies here if the board would like to have copies. I've got plenty for the board that we can share. The applicant and the precinct have reached consensus. The agreement has been drafted. I believe the precinct is due to sign it this week. It was forwarded to Glenview approximately 2 days ago by counsel for the precinct. And all of the concerns that Glenview has voiced in prior discussions have been addressed and taken care of. At this point, we're waiting to hear back from them. They need to have an opportunity now to review the terms. There's really no obligations in the agreement imposed on Glenview. It basically contemplates them being relieved of all responsibility associated with the water booster station. The precinct will own the equipment and maintain it. It will serve both Glenview and this new subdivision, and the only surcharges that will be imposed will be on the new lots created by this new subdivision, simply because this subdivision is slightly outside the precinct's jurisdiction. So we anticipate that that will be acceptable to the homeowners over in Glenview, and we're waiting to hear from them with any comments they may have. So at that point, the water's been taken care of, and all the details will be dealt with by myself or Attorney Tucker. Number 2, the board finds the cutting of the trees is a material change in the aesthetics of the property, but could be mitigated by the proposed modification to the open space covenant. That has been done. What we're waiting for is the board's final approval of the instrument. I don't know if that will come from the board or legal counsel. It does call for a 20% donation to the Conservation Commission in the future should any other forestry management take place in the open space. And there's income from that forest management effort. The applicant will make the $8,000 donation to the Conservation Commission Fund as agreed to at that October meeting. Once he gets the bonding in place and the plan is signed and he moves forward, as the final monetary aspects of the project are dealt with, that will be done simultaneously. Number 3, no further cutting on the property. There has been no further cutting, and there won't be without the board's approval and the submission of a plan. Number 4, the applicant provides evidence ensuring good title for the easements which are to be granted. Shortly after the meeting where this was identified, I sent a letter to the board with copies of the deeds that expressly reserve in the instruments for those easements. Number 5, the board approves the remediation plan proposed by the applicant. The board did approve that. And number 6, the applicant provides a report on the progress of the remediation in the disturbed areas as well as on the road. Both have been completed. They've been inspected by Megan, and I believe Megan's approved all that work. She's been out to inspect. Other details. Done. The plans are in final form, but for one aspect of the project, in that the applicant is now proposing that we phase the project, simply because of the marketplace, as well as to keep the exposure associated with the bonding reasonable, and because it will allow the lots to be sold over a longer period of time, which we don't anticipate the town would object to. What we're looking for this evening is whether the board will entertain that, and how the board would like to see us prepare the final documents, if that's acceptable, for the board to final approve. To give the board a little more information about that, Phase 1 will include all the improvements on Worthley Hill Road, which will also include the extension of the sewer and the water line and the improvements to the road. Those go along the frontage lots that are part of this subdivision. Phase 2 will be the first cul-de-sac and the lots that are on that cul-de-sac. Phase 3 will be the last cul-de-sac in those lots. As part of this proposal, we would like the board to consider finding that once Phase 1 is completed, inspected and approved by the town, that would constitute substantial completion for the purposes of vesting, simply because it is a substantial investment in off-site improvements for the town.
Question, can I just have a question on what we're talking about here, if, excuse me? When I looked through my stuff, I saw this as a request for a 90-day extension. I didn't see anything about a phasing request, and I can tell you right now, I didn't get anything in my packet that I would have deemed sufficient to review such a question. I don't know whether you gave things to people and we didn't get it, but I mean, I sort of know it's number 6 in this write-up, but I sort of saw that as a potential request within the next 90 days and nothing that was getting addressed tonight. And I know I don't have any material on it, and I know I have a plan, but when you start talking about lots and cul-de-sacs, and I haven't done that. I didn't see that for review, so I have a question for the chair. I read the letter to the planning board from council as being a 90-day extension request to an update on what we discussed. And, I mean, I know it was in the report, but I didn't understand that's what we would be addressing tonight, because the staff recommendations for tonight didn't have anything about a phasing request in it.
Duly noted.
May I respond to that?
One more, please. Brian, anything, any comment on the record that we don't have here, you might be aware of, that,
Or maybe Patty.
well, Patty can also pipe
They
in
could
here.
give him a break.
Mr. Chair, in looking at the staff report written by Stephen, it does state in here that a phasing proposal to be properly noticed and approved by the board at a future meeting, with the first phase being on the lots on Worthley Hill Road with public water and Worthley Hill Road improvements being part of this first phase, and with their acceptance being sufficient for vesting the remainder of the subdivision. So it does state in there that it would be at a future meeting when a phasing proposal would be noticed and approved by this board.
Jim, I'd request we let the applicant, it's really in the form of a conceptual presentation, just to let us know what's coming down the pike, but we're not acting on that.
All right, I
tonight.
mean, that's fine, I was
Yeah.
just sort of hearing this.
Just procedural,
and
that's not before it's a
looking-
formal applicant, but she's wedded our appetite,
Understood that we
so.
will not act on this?
Absolutely. Absolutely.
Please.
And thank you, Member Raymond. I did discuss it with Steve, and we both felt it was worthwhile to just introduce it to the board tonight. We're not applying for it, nor are we asking for approval. But being that we're coming in here to update the board on all the loose ends with the project, we thought it was worthwhile to put it on the table. Absolutely. Okay.
You did, please.
So that was that aspect of what I had to say, and I don't have a whole lot more to say. The other issues that are still outstanding are the off-site improvements associated with the improvements down at the end of Worthley Hill Road, and there's a little circle apparently that there's a contribution required proportional to the size of the project that the applicant has been discussing with Department of Public Works and the Selectmen. It's a monetary contribution, and it's a percentage interest. The difficulty, from what I understand, is the whole hasn't been established to apply the percentage to it. But they are working through that. We have also provided the town with a suggested or proposed list of bonding items for Megan's review and approval and modification, I'm sure, when she returns it to us. And of course, at that point also, that will require consideration in a future phasing application. So that was why I was introducing it, because it all plays into the final details. The last item that would need to be done is we will have to return to the board, hopefully when we come back with a formal discussion of the phasing, and request the board's final approval, and hopefully by then we will have heard from Glenview regarding the tri-party agreement, because their declaration of covenants requires that this board approve them being released from the obligation to maintain that water booster station. So that's a minor item, but we'll try to wrap it all into one presentation. And if the board has questions, I'll be happy to answer them. Mr. Baskerville's here, and he can answer any questions on the plan.
As a matter of justice here, I need to backtrack a little bit. I'm new on the block, the new kid on the block.
I move that we
Requires a
find,
motion here.
I move that we find this application complete and ready to be heard.
Thank you. Can I have a second to that?
No, I'm sorry I'm late. I have to recuse myself from this. So just slide back. Okay.
Just slide.
Now that you're here.
Do I hear a second to the motion?
Second.
Any discussion on that motion? All those in favor say aye.
Aye.
Opposed? Motion carries. Now that I've taken care of my misstep here. Jim?
I guess I have to ask Patty, because she's been here longer, have there been any zoning or planning changes since, the last time we saw this that would influence our decision on whether to grant an extension?
No.
Tim?
I heard Attorney Pansiaco talk about the improvements to the intersection. Did we finalize, or did Public Works agree with a realignment of Lamson Road as part of the final approval?
Correct me if I'm wrong, can you address that, Phil, is the status of the design of that roundabout?
It's complete.
Megan?
Yeah, the realignment of where the road is gonna become part of the roundabout project, and we're going to find the design of that, in the next, we'll come up as to what the design will be on, working with the base survey information. So, once I have that done, the roundabout estimate is almost done also. So, once I have those two, I believe, it was gonna be like a percentage of those two items. So the way I understood it, and I have to look back at the traffic reports, we had some emails going back and forth. It's like a percentage based on the traffic impact, so I believe the traffic impact at the Wallace intersection with, South Mass was like, say, 2%.
Right.
So therefore, it would be a 2% of the cost estimate for the roundabout. But my thought was we're also applying that to the Worthley intersection, and whatever the traffic increase was at the Worthley intersection, I don't remember the number at all, maybe it was like 25 or something percent, then it would be 25% of the Worthley realignment. That was my take on it, and we'll go through those things with them, but that's what we're working on.
Tim?
Well, I remember as part of our discussion, there was a lot line adjustment made to the lot on the triangle that was owned by the applicant, and they gave up a portion of that lot to accommodate the realignment of Lamson.
I don't think there's a lot line adjustment, I believe it is just an easement.
It's recorded deed subject to the easement as associated with the plan.
Okay, well, I just said it wrong then. So, but is Lamson going to be incorporated into this, Lamson Drive coming out differently as part of this
No, it'll end
redesign
up
of-
being a T intersection essentially. So Lamson is gonna come out, and then straight across from that is going to be the Worthley. You know, we're working on it now, I mean, but the idea that we have come up with is a T intersection. Originally, on the roundabout plans, they had shown just kinda curving it in slightly, on the McFarland Johnson plans, but that was before, you know, this had been approved and everything, and now that we have the easement, and once I know the exact locations of the easement, we're gonna shift that up. And, way back when this was in front of the board, we had looked at a few different concepts. And so I believe Carl just recently went to the Board of Selectmen and revisited those concepts and came up with one that, we feel is the best option that, works
been talking with them too, you know, in the residence and gets the intersection away from the
Okay, that's
roundabout
kind
as
of
much
what-
as
yeah.
possible,
Right.
so.
Thank you.
Mr. Chair,
Yes.
I apologize for also trying to backtrack, but, does this have to also find, that the application does not have a regional impact?
I amend my prior motion. Include that.
Second.
Yeah. Do I hear a reiteration on the second, Jim?
Who's Phil?
Phil?
He just did it.
All those in favor?
Aye.
Say aye. I will learn before the next meeting.
Right.
And this will be the fine print in the staff recommendation.
Open it to public comment. Anybody wish to speak in reference to this time extension request? Seeing none, I'll close the public hearing.
I move that we grant the extension request, finding that there's been no change in our zoning or rules, that the applicant is making progress. I could call it significant, but I don't think we need to get there. And is to be addressing the outstanding items, some of which require action by the town to finish its construction's premature. And this is solely on the request to extend.
Yes.
Just a question, Megan, and this is more, I guess, information, not so much subject to the motion. I know that the drainage stuff was done last fall and it was looked at, but I noticed that the last couple of storms, crews have had to be up there. What's going on up there? They needed to go up and clean that up subsequent to last fall.
The catch basin's way at the top, what's happening is
And
those are
even
just-
further down.
Yeah, they're getting jammed with leaves and rocks, really. I had my field house to go up there and look at that, just to make sure everything was all set for the clearing. And it's really just typical stuff that happened for us up there, that those jam up with some of the stones that are in the
Okay,
river
so
as
nothing's
well.
had to be reworked?
No, it's common maintenance for us, and when this moves to the phase one, where we redo all the drainage, hopefully we won't have to be up there anymore dealing with that, but it's a small swale that takes a lot of water, and, when this all goes through, one of the things that we've achieved with this, site plan, subdivision plan, is, to reduce the water that's coming down the hill, because of the addition of some detention ponds. The idea is to take some of the water, reduce it, and then bring it back out onto Worthy Hill, so that should really help a lot. But unfortunately, we're just dealing with what we have right now.
But it wasn't anything structural when the crews were up there?
No.
Okay. And then I have a question for the applicant. I just took a quick look at the documents that apparently got done this week and given to people, the tri-party agreement. And I noticed that there is a provision, Glenview has to turn over the booster station. I think the water precinct is gonna take it over, which was a big
Yes.
point of dispute back
Yes.
when you were here before. But that booster station would still be there, subject to the approval of the, I forget what the name of the development, the Tyler Drive neighborhood, which had a, noise and distance restriction, which I noticed there's no request to change that.
No.
And I know you had said they can do anything, so you understand that the applicant represents that all those booster station conditions of the original approval remain in effect?
Yes.
Okay.
Any other questions? Move the motion, all those in favor say aye.
Aye.
Those opposed?
No, I said 90 days ago they wouldn't get it done, and they had plenty of time to do it, and it's still not done, so, no.
Motion carries, chair votes yes. Thank you.
Mr. Chairman,
Yes,
is Carl a voting member tonight at this point? He wasn't, I think he was up until a minute ago, until Carlos arrived, I believe.
yes.
So he's still a voting member right now?
The seventh.
Okay, just making sure we
Yeah. You get-
tell
you
him
make
when
the
he is or
adjustment.
isn't, since
Okay.
No,
alternate.
my digital computer, I was counting.
Digits, yeah.
Get to seven, that's how you put it.
Okay, just asking, make sure he knows.
Good point.
Moving on. Item number 2 is map 4, lot 87-3 and 77 final subdivision review hearing for proposed lot consolidation and 3-lot subdivision, Thomas Lally Revocable Trust, Lesniak Road and Checkerberry Lane, zoned R1 and wetland, and surface water conservation district overlay, continued from February 25th. Members of the board. Actually, Brian. Gotta find my Start out with hearing we'll open a public hearing to hear an applicant's presentation. Mr. Todd.
Good evening, Mr. Chairman. Congratulations.
I'll let you know later
You let me know what later.
how it goes.
I have no reason to believe it won't go very well. Good evening, I'm Robert Todd, and I am representing Mr. and Mrs. Lally this evening. This is a continued public hearing stemming from the meeting on February 25th. At that time, there was a request for a engineer's report on the sizing of culverts, one of those being the one under Lesnick Road that drains onto the subject property, the size of the culvert that would serve the common driveway in the project itself. Number 3, the size of the culvert that runs under the driveway serving the abutting property to the north, and a final culvert which carries stormwater underneath Evergreen, that stormwater coming through the subject property down the edge of the public highway to that culvert being about 300 feet on the north line of our property. That engineer's report was completed, and there were some changes to our plans.
Must be more than that.
For the subdivision. As a result of that, we submitted, or I should say, the engineer's report and drainage plans were submitted on March 12th. That was, I believe, given a very thorough review by Megan from the Department of Public Works. And on the 1st of April, I received comments from the planning department, which included the report from Megan. And those changes that she suggested are in the process of being completed. We didn't quite get it done in time to get it to the planning department so that you could see all the changes here tonight. But I can say that the changes were not terribly significant. I mean, as far as they were significant for planning purposes, but I mean, they weren't difficult to deal with. And it's just that my office couldn't get the revisions done and get them to you in time for distribution.
We shouldn't be talking about this. Then we shouldn't be talking about
There were some questions in her report that didn't require any plan revisions. One of those was in regards to placing the rain gardens within the protective well radius for the wells on the 2 new lots. And we looked through the DES rules and we couldn't find where rain gardens were a limitation with respect to placement of wells. But considering that we had lots big enough to move the well location so that the protective well radius did not overlap the rain gardens, we went ahead and did it anyway. So it's a non-issue, and that, I think will work out quite well. There was a request for adding a mulch layer to the top of the rain garden and rain gardens, and that has been accommodated. There was a question about the condition of having rain garden installations inspected while they're being constructed or after they've been constructed, to make sure that they were done according to the plan and put in the right locations. And I think that's probably a good idea. It is a good idea. And I think that could be handled as a condition of approval to the subdivision. Maybe it could be a note on the plan, or it could be a condition of granting a building permit, I suppose, so that the building inspector could make sure that the expert that is inspecting the installation of these rain gardens be given an opportunity to make his inspection and make a report to the building inspector. Whether that would work or not, I ask for your guidance, but that's a suggestion that our office had. The culvert that takes the flow through the property and carries it underneath the proposed common driveway was sized up to what the engineer recommended when he made his study of the flow, and we have shown it as a 24-inch culvert. And there's a statement at the end of Megan's report that says that the town is not going to replace those culverts. The one coming under Lesnick Road takes drainage onto the property, and the one that takes the same flow under Evergreen immediately. And there's not going to be an immediate or an imminent change in the size of those culverts. So she said that our original culvert size could have remained, but we think it prudent to keep the 24-inch culvert there, just in case the town decides to increase the size of the culvert coming under Lesnick Road, and therefore avoiding future expenses by the people who might buy these two lots. So we're going to stay with a 24-inch culvert there, Megan. The applicant will also take your recommendation that the culvert that takes the flow underneath the driveway of the abutter to the north be extended southerly to a point where it's nearly adjacent to the culvert that takes the flow underneath Checkerberry Lane, and which discharges just to the north of the subject property line. At that point, there would be a plunge pool that is properly protected, and also would have a culvert with a substantial header that would resist erosion that would occur from flow coming to that inlet, and it would increase that culvert length between 20 or 30 feet and discharge it into the ditch downstream as it does now. The plan also calls for, what Megan's suggestion was, that there be a grass swale, vegetated swale on the east side of Checkerberry, the length of the frontage on said Checkerberry Lane. So that's been incorporated into the drawing. There were a number of plan edits that Megan suggested. All of those have been addressed, and there was some computations that she wanted for the rain garden, and that was about the only thing we had left to do, and we didn't quite make it to get the work down to you. But I don't think we'll have any problems complying with all all of her suggestions. What I have in addition are some documents that have been listed as being required. One of them is a drainage maintenance agreement, which I'm going to give to Brian for review. Have town council review. There is a declaration of common driveway easement which represents, once it's recorded, that when these lots are sold, Mr. Lally will make sure that those common, there'll be a right of benefit and a right of easement and a subject to easement for the common driveway that would go with each of those lots. You can't make an easement now because he already owns the land, so the only answer that our lawyer came up with was to file a declaration of common driveway easement, which I think is appropriate.
Question on the drainage easement. Who are the parties to the drainage easement?
That would be the proposed
The
owners.
the drainage maintenance thing? Who are the parties to that?
Do you
Does it
wanna-
say on that document or not? Who does it have signing it?
Mr. Thomas E. Lally.
The current owner, yeah?
He is the current owner, that's
Yeah.
correct.
And then it's signed by a notary public.
Okay, thank you.
Okay.
There is a waiver of municipal liability for a shared driveway, which is an agreement and release.
Right.
And this is a release of liability for the existing well. This property has a well
The house.
right here. Only half of its protective well radius is on the property, the rest of it spills across the road
Right.
onto the neighbor's lot across the street. So we're releasing the town's liability for anything that might happen as a result of not having a protective well radius. This, I believe, has already been submitted once, but it was still in the report from the planning department as being something required, so we wanted to make sure that you had it, so we brought another copy. I believe that we're so close to having this finished, and at the point where everything that remains has to do with legal review and making sure that Megan is satisfied by the changes we've made to the plan. So we're looking for a conditional approval, both precedent and subsequent, so I'm willing to answer any further questions and interested in hearing any further input from the public as well as the members of the board.
Members of the board.
Well, I'm looking at Megan's first comment on page 16 of the package on the maintenance. Maybe that maintenance agreement addresses it, but there's two, well, among the concerns, one is three. One is requiring maintenance, two is verifying that maintenance occurs. It's maintenance has to be done, how do we make sure it's done, and what's our remedy if it's not? And I think Megan's concern is because there is some, it could be material to the impact of the project on either the roads or abutters that it be done, but not impose obligations on the town resources that would minimize the commitment of town resources. So, perhaps the maintenance agreement that I haven't seen accomplishes that, but maybe Mr. Todd could address that briefly.
Is that similar to the agreement we get for retention ponds or whatever?
Usually if there are retention ponds, you have owners associations, and that's who you're doing the agreement with. I apologize for interrupting, but I see that as sort of a basic difference to a 3-lot subdivision.
It's similar but different?
Thank you.
See, he cleared it up even more.
Lawyer Reeves. Megan, you raised your hand, please.
No, I was just gonna say, there's drainage easements and drainage maintenance agreements. I mean, with the typical detention pond, the town is given a drainage easement, and
Right.
at least on a public road, we would be in charge of maintaining it. In this case, which I had raised my hand earlier about, there should be 2 documents, a drainage easement and then a drainage maintenance agreement. The drainage easement is for the town's culvert pipe that's under Lesnick Road at the outlet side. So we need an easement to the town for that, which I'm not sure when you were listing off the different documents if you said that.
That is one that we have not yet prepared.
Okay, so that is needed, regardless of whether or not right now, the plan is for now in the future to not upsize that pipe. But still, it's proper to get an easement at this time for it anyway. And then the other agreement is a drainage maintenance agreement, which, Carl and I and Mike Hillhouse all went to meet with Drescher about, our attorney, about several different issues. And this was one of them on how to handle these rain gardens and bioretention areas. And he said the only way to handle it is with the, recordable declaration of covenants, with the ability to lien a property, if the conditions that you require, are not met. And Steve and I had talked a little further in some emails, and I don't think Drescher had responded, but the, declaration of covenants that I had seen Steve write up was very generic and applied to almost any kind of homeowner association or private, site. It wasn't very specific at all about what the actual requirements of this site will be. And so I said to Steve, I'm hoping that there'll be a second either attachment to that declaration that lays out exactly what the requirements are going to be, like what maintenance procedures we're expecting them to do and when, because you've got to lay that out somewhere. So I'm not sure how that's all gonna work out. Steve had kinda notified Drescher and asked him to review, I think, the declaration of covenants, and I don't know if we have heard back yet. But for me, I wanna make sure somewhere in writing, it's gonna tell these people what they have to do and when. To me, that's very important. You can't just say maintain it, it's up to you, and they're gonna need specific instructions on that.
Phil?
Right along that line, we discussed this at the last time, because I brought up that issue about people filling this in down later on. And I think what is needed, as what Megan said, that she wasn't sure what was needed there. What came to my mind on it is, the only way that I could see that this could be done in the future is, let's say that when, at some point, this property is sold, and at the closing, part of the closing documents between the mortgagee and the mortgagor, that there's a document that's signed by the buyer, that's held by finance, that lays out the obligations, and so that everybody is aware that the owner, the buyer of the property, is responsible for that. And if they don't do that, they have a problem with their mortgage. I don't know exactly how you get to that, but I think, because that would be the only hammer that I could, what we lack on current things like this is some type of a hammer over the owner to make sure that they enforce that this is done. We have no enforcement. So the only other thing that I see that could be a possible enforcement is between the owner and their finance. That it's a recorded document and they sign the agreement that they have to maintain that, or they're in violation of their mortgage.
Well, I just want to comment in general, I agree, and I think we need to nail this down, because bioretention and rain gardens are state-of-the-art technology when it comes to stormwater management these days. They're highly successful, they're used in many, many areas, and I think we as a community need to be promoting this sort of stormwater technology. And if we need to go to great lengths to make sure that we've absolutely wrapped up the legal requirements through whatever mechanisms are necessary, then I think it behooves us to do that right now, so that we can lay the groundwork for all the future ones that come in, because I think we ought to be, if not promoting these, requiring them on residential subdivisions in town.
Tim, you have anything?
Well, when you're all done with your rain gardens, yes. Make sure no one else wants to talk about rain gardens. I don't want to
Carl?
interrupt it.
I just had a question for Megan with regards to the sizing of them. Is there a specific means to size these rain gardens? Because I see you use a 10-year storm in the notes here.
What I used, was the new, stormwater manual that came out.
Okay.
Has some information. They have two different types of formulas that you can use to size them, and I'm not very familiar with it. This is
It's brand new.
So I used, one of the formulas in here. I think it was the, water quality volume formula. I used the formula in here, and, based on like the impervious area shown on the
Sure.
plan and the size of the lot, and I came up with a very similar number to what they had, but they didn't use the same formula, and so I asked them to use this formula so that as I get these, and if I see this again, I can say, use this formula right in this book, so that when I get it, I can compare to this book. And I said the 10-year because that's what this says, that sizing is based on a
Okay.
10-year, so I stated that in my report.
Okay.
And, again, this is different than what I'm used to seeing. These are not sized like in this drainage model, which is what I'm used to seeing. It's like a detention pond, it's all sized in here. These are just sized with what appears to be a simple formula, just right on the plan. So it's not like in here we have a 2, 5, 10, 25-year
25,
storm, so.
right.
Again, I'm just going off what I've read so far, and I recently, again, knowing this was coming up tonight, I had asked, Collis for some help in the future, maybe with just making sure I'm reviewing these correctly.
Thank you.
Any other board members? I'll take,
Now I will.
Tim.
Sure, you have short memory for a new chairman. I'm gonna go back to, something I discussed with Mr. Todd at our previous meeting, and that's the common driveway. I personally feel it's an overly aggressive common driveway. There's a lot of pavement. I know it's tried to accommodate NFPA requirements for the fire department, but I think there are other avenues to accommodate the fire department and their needs. I'm looking at all the pavement that the landowners are gonna have to be responsible for on their properties. I would think that a more traditional common driveway with a split and an accommodating area to turn a fire truck around would be more than adequate. I think this looks a lot like a small town road, and I will not vote for a project that has something like this, because people will come back and they'll petition the Board of Selectmen to come and take care of this for them in another 5 years because they can't afford to pay for the paving when the paving needs to be redone, or the ditches are filled up, or the culvert pipe doesn't work. So I'm wondering if he would entertain any suggestions to downsize this common driveway to a more traditional common driveway without the cul-de-sac portion of it.
You give me a letter from Lieutenant Connor that will guarantee his approval, and I'll be happy to.
Well, I don't believe that the fire department requires you to put in a full 60-foot diameter cul-de-sac. They require, if I'm not mistaken, a 16-foot wide all-weather surface and a spot big enough to turn a fire truck around, which could be a hammerhead or another sort of driveway device. I just don't like this idea of what looks like a town road to service these two houses.
Hearing that, are there any members of the public who wish to speak for or against this project? Open it to public hearing. Yes, sir.
Yes, my name is John Pelton, and my wife and I have property that abuts the Lally's property. Just a few comments. I understand some legal documents were produced today, and Ian and saw Patty earlier this week and got what was then available. I would like to review those because some of the concerns that I have would be addressed by those documents, and I appreciate the fact that these documents are intended to address those concerns, and I'd like to see how it's done. So I assume before there's an approval that the public will have an opportunity to review some of these documents and the new plan that's gonna be coming in. On the rain gardens, I have a question whether a 10-year formula is adequate. And I have not read the new stormwater manual, and would defer obviously to Collis and to others at DES and to Megan, who's at least taken a stab at it. We just know that out there's an awful lot of water that comes down off the mountain and gets into this property. And for what these rain gardens, these particular rain gardens are designed to do on this property, is the 10-year rule gonna be enough? Also, I would assume that there will be a condition that, a condition of approval, that that at some point, someone's gonna figure out whether these rain gardens will work. I'm not gonna pretend that I know much about them, but they're an infiltration mechanism which requires some amount of Vado soil over the groundwater table. It's a very shallow groundwater table out there, as we know, and so they're now being relocated to another area, and I understand there's some room to move them around, and I think Mr. Todd's idea of getting it out of the 100-foot well radius is a good one. You just wanna make sure that wherever they go, will they work, and I'm not sure that the plan that's been presented tells us that. And Mr. Todd obviously intends for them to work, and I accept that, but I don't know that the requisite work has been done to make sure there's enough dry ground out there to, for them to work. So, my other questions about the rain gardens have been answered. I am concerned about the verification and the remedy in the event that the owners don't maintain them. But that is something I think that Mr. Todd and the Lalleys are trying to address in these documents, and I just want to have a chance to review that as well. I don't know on the maintenance agreement, this is gonna be a 3-lot subdivision. I would assume that all 3 lot owners are responsible for the maintenance. But I don't know how that covenant is going to shape out, and I'd like to look at that as well. With respect to the size of the driveway, by the way, I just wonder, making it smaller was one suggestion, so that it doesn't become a town road. Is there a way, since we're dealing with covenants here, that there can be a covenant that runs with the land that says this is going to always be a shared driveway, and that it will not be a town road, and that people will not ask that it be made a town road. I'm not quite sure I know why, if someone petitions that it be made into a town road, the town has to incur the cost of doing all the work to bring it up to speed for a town road. But if that's the case, then perhaps a simple covenant. No one intends, I guess I'd like a condition, by the way, that this is the last of these subdivisions. We're gonna have 3 lots and that's it. We're not gonna be hearing more later on, because that would go to whether this is a shared driveway or a roadway also. So I think that would be a fair condition to set, but if there's a simple covenant that says the parties accept this as a shared drive and will not seek to have it made into a roadway, I think that might work. I put it out there as a suggestion. Let's see. Mr. Dodd explained to me the last time, and I appreciated the explanation, and others on the board explained to me why I was misreading it. I just want to reiterate my concern. There is a septic system. The leach field is on the boundary, and Mr. Todd tried to give me comfort that that's there, only because that's where the water pit was dug, test pit was dug, and it would probably be moved back closer to the house, and I just want to make sure that that's still contemplated. I think Mr. Todd said last time that the trees were going to be kept. Obviously, they have to be, some trees have to be cut for the driveway and for the houses, but I believe he said that that was going to be done, and I would urge the board to consider a no-cutting condition, except for the house lots, for the construction of the homes and the driveways. If only because with how wet this whole area is and how much water comes down off the mountain into this area, the trees are an aid for water management out there. So I think it would warrant a no-cut condition. I believe either Megan or Steve's comments have in here an omnibus provision that says the applicants will comply with applicable local, state, and federal laws and regulations, at least regarding wetlands and stormwater management, and I am assuming that'll be there. And then I had a hard time, my fault, not anyone else's, I had a hard time understanding the detention, I think these are detention ponds north of the driveway, how they are sized. I assume they're not sized for a 10-year storm, but I could not tell from reading this what they're sized for, and I'm just curious to know what they're sized for. And I did notice the maintenance. I have a small print, it's hard for me to read, but I believe there's an awful lot of maintenance laid out on the plan itself, which includes an inspection and necessary maintenance after even a 5/10 of an inch rainstorm. So the owners have a lot of obligations here, and that just highlights the need for the maintenance agreement. There are other maintenance requirements here, but it highlights the need for a maintenance agreement that the town can enforce and that the town, for which the town has a remedy. And I think a lien the ability to lien might be a good one, and notifying, or having the mortgagor buy into it is probably a good one as well. Those are my comments at the moment. Thank you very much.
Thank you. Just as a point of reference, Mr. Todd, these two rain gardens are to assist in the drainage of just the driveway, not the drainage that goes through the property. Is that correct?
That's correct.
So it's just water off the driveway
And
that
the
these rain gardens.
The waters that shed off the houses and the driveway, right?
The rain garden here is strictly based upon topography and location, is primarily just the driveway.
Well,
It depends.
land
House too.
uphill from it, of course.
Yeah.
Okay, so I just want everybody to understand, it's not taking the drainage that exists there now, that goes through the property, just continues to do that, as it has always done.
These, just so you know, the two rain gardens on one of the lots, would intersect that water as it goes down into my property. The other two, the other two, the other lot goes down north of the property line.
Okay. Any other
Thank
public
you.
comment? Yes.
Good evening. My name is Kathy Prescaza. We're a neighbor in the neighborhood. We live to the north of the subject property. There's one lot in between our lot and the subject property. We are coincidentally downhill from the subject property as well. And I'm very concerned for primarily two reasons. Before I get into those, I just want to
Is
commend...
this new information that
It
you
is.
haven't presented before?
It is. I want to commend the applicant for being a single-family development, and the size and scope, I think, is appropriate for the neighborhood. I am concerned about the water quality of the drainage into the rainwater, the rain garden assemblies. We do have a history of contamination of our well from development on the property to the north, immediate north of our property. We have a dug well, so that means it's surface water. And we've invested thousands and thousands of dollars to have a water treatment system in our home, and it currently makes that water potable. I'm concerned that if this development happens to the north of that, which is down uphill from our well source, that we are ensured that the disturbance of the soils will not impact our water quality. I have a section from our Goffstown Appendix C of our Goffstown Master Plan, latest edition. It talks about the conservation need to not harm the natural environment it talks about a particular concern, I'm reading from page 2, is the area of conservation that require, of particular concern, in the area of conservation are the town's groundwater and surface water supplies, which contribute to existing drinking water supplies. I go back to page 4, C4. Our own master plan refers to conservation for existing and future needs. The town should take particular action to protect its groundwater resources and before additional development occurs within sensitive aquifer areas. A case in point is the construction of the middle school along with its associated septic system in a location which is uphill from several private wells. It is essential that the town develop and institute a plan to monitor the septic system in order to protect these wells from contamination. I have a directly applicable situation to that. There's the rainwater and the septic system are directly uphill from my property. So I would like to, in this month, in between now and the next meeting, apparently there are some additional documents, I'd like to work with the owner and see if we can come up with an agreement for testing of our well, or maybe a new well that would accommodate the safety of our water system, as well as allow him to develop his property in a way that allows him to use the rights of his land as well. So I do want to say that. I think it's really important in keeping with our master plan so that all of our residents can coexist safely. The other thing is the neighbors across the street also unearthed some antique bottles when they were excavating, and there are rock walls along back there as well. So I wonder if there's been a historic inventory of assets on this property, and if the board feels that would be important.
I think those were my Uncle George's beer bottles when he was.
And medicine bottles too, apparently.
Please. Any other people wish to speak for or against this project? Okay, now close.
Well, question before you
Yes.
do. Mr. Tard asked that we grant conditional approval. Are we ready to do that, or are the what's left to be reviewed sufficient? For example, I haven't seen the homeowner documents. Maybe they were circulated earlier, but maybe I saw them and had forgotten. That's equally possible. But to me, those are material to the review, and much as I think highly of Attorney Drescher, maybe we want to see them because there's some precedent, as Collis pointed out, that we're establishing on how we're going to go forward.
Before we move the project, or before we close the public hearing?
Well,
Leave it open?
if they are material to our consideration, then the public has a right to comment on them. If they're not material, and that's just an administrative review, then we could close it. But if we think it's important for us to look at them, I think the public has a right to see them and comment on them, which means the hearing has to stay open.
Yes, Barbara.
I did not go through the previous information that I had for this application from my papers. So I apologize to the board that I did not do that. But in follow-up to Tim's comment on this driveway, I noticed on the planning board summary, and I'm gonna look to Patty for this, not you, where we get the subdivision review recommendations and we go through the history, and we usually get it sort of the same every meeting, and then it just gets updated. And I think this is more of the TRC comments that we usually have attached to the subdivision notes. So maybe there were TRC comments in a previous packet that I don't have here. But I see the DPW comments, but I don't, for example, see fire department comments on our summary, which is, we do normally see, we sort of see fire department, no comment, and maybe it's 'cause it's on that TRC document that I don't see, 'cause it sort of goes to Tim in this driveway that looks like a road. And I'm sure the applicant is not proposing to put lots more pavement down if he doesn't have to, because it's expensive, so I'm not doubting that Lieutenant Connor wanted this. But it does appear to be a lot of pavement. I'm not seeing this, and as to concerns of an abutter for this ever becoming a public road, I can tell you there are roads all over town that we maintain now that were private when they started, that come in, and it does sort of look like a road. I mean, it happens all the time. So I guess I am sort of curious as to whether Patty has any recollection of what the history was with the fire department on this road, because this plan is obviously material different than the first one we saw.
Steve did this was Steve's review, and Megan's comments came in after Steve had left, and I inserted her comments. Generally, they want the driveway constructed to meet the National Fire Protection codes, and based on the length, too. Isn't that what they generally require?
Yes.
Anything over 600
I don't
feet.
remember any comments directly from Bill Connor in any of the TRC meetings recently, but sometimes the engineers go directly and work with Bill, so that's maybe what's happening, so maybe Bill's issues have been
all right.
resolved, and that's why we didn't see any comments on our end.
Well, I'll go back in my files here to January 22nd, '09.
Okay.
Fire department comment. Cistern size relates to building size. Department will provide maximum building sizes for adding to the plan.
Which plan was that, though?
The first one.
That was the first one.
Well, so, then that doesn't,
I haven't seen this.
No.
May I follow up with a comment?
Just a moment.
I have a question, but it's not related to this, so.
Please, Mr. Todd, you have the floor.
Thank you. The input of the fire protection officer, Lieutenant Connor, has been incorporated into at least 2 subdivisions that I can remember that my office completed. One of them was from Addison Road, the 3-lot subdivision.
Correct.
Can't remember the client's name, but the road was built to NFPA standards, approved by Lieutenant Connor. He thought that a narrower street would be acceptable, and as I recall, that was a 20-foot wide travel surface. And the turnaround was a hammerhead, if I remember.
That is correct. It was 16-foot wide, 2-foot shoulders,
16-foot wide, okay.
as I looked.
Addison is a road, though, this is a driveway. The one you're referring to.
It's a private road, though, is it not?
It's a private
Yes,
road.
yes.
This is gonna be considered a shared driveway.
The other one I'm thinking about actually was not a subdivision. Yes, it was. It was a subdivision, but the house for the second lot was back further than 300 feet from the public highway. So I was asked to design a radius 65-foot or 60-foot turnaround. And that was approved by the board, and it was constructed. So it's kind of been a procedure that my office has used in designing the roads, and it's been Lieutenant Connor's guidance that I've gone by. So if I can get something less, that'd be great. It's his guidance we're going by.
As chair, can I ask Brian to obtain a copy of these NFPA standards? Quite possibly educate the board sometime about what these are in a little 15-minute session. It might help clarify future issues.
Yes, I can obtain that. I would like to maybe just make a comment. From my previous experience in working in Arizona, our fire department never liked to do backing up of their fire trucks. So that would be like the hammerhead type of situation where they would pull in, back up into a hammerhead. They like the turnaround. So that's just an extra opinion of another fire department, but.
Well, I'll defer to Carlos, he can, but I have a response to that, which is, yeah, so what? Of course they do, they'd like to see a 100-foot water drop.
We need to have a conversation with the fire department. We're only talking 300 feet from the road all the way to the farthest house. 300 feet.
In an environmentally sensitive area.
Good grief, and we're gonna build a cul-de-sac?
I thought it was 600 feet was the.
Yeah,
So that we don't have to back a fire truck up 200 feet? I mean, I bet I could back a fire truck up 200 feet.
The reason for that is not because they don't like to, but because it saves them a couple of seconds when they're trying to respond to a next call.
May I say something?
Yes, you may.
It's our job to, when I say compromise or balance the different needs. And just because a certain municipal group in town, department, wants a certain thing, we don't have to give it because there are contrary values. And an example in a different context, and we came up a few years ago, is widths of road. Fire departments like wide roads. A lot of studies show narrow roads are safer because cars slow down, which is counterintuitive, but that's the study. So we concluded we're going to make our roads narrower in many circumstances, and the fire department will have to figure out how to get down them. Well, this is a similar case that we can say the environmental values outweigh the 2 seconds that the fire department has. Not they're not wrong in requesting it, but we're not compelled to do it because it's their request. And that's this board's role. And I don't have a problem with saying in an environmentally sensitive area that we would look at alternate designs and permit them to do it.
Okay.
I wish that we had heard this discussion very early on.
Well, I mean, in all fairness, this plan has changed.
Yeah, I guess we had other things we were
You heard it a
focused on,
month
I
ago
guess,
from
so,
me.
yeah.
Well, is it fair to say that if the board would like to continue this public hearing to a point where the documents in terms of easements and covenants and other restrictive devices, declaration of covenants, those kinds of things are determined and approved and reviewed by council and staff, I would certainly entertain a motion to continue.
Well, I mean, I think we're also hearing that this driveway needs to be looked at. I don't know.
Well, it's part of that. The second part of that would be, do we want to give Mr. Todd some direction of what the board feels is appropriate in this particular situation?
I'll defer to Carlos in that, he's the engineer.
I think
Carlos?
that's fair. I mean, to give them direction as to where we wanna go.
I would insist on it, because I've been here too often already.
Okay. Yeah, I wanna get back, we talked about the driveway a little bit, I wanna get back to the rain guards, because there was a good comment made that these are infiltration practices, and if they're not up and out of the groundwater, then they don't serve the purpose they're designed to serve. And without any soils information relative to where the seasonal high water table is?
Well, we've done that.
Okay, well, maybe it's there, I just.
We had a huge detention basin designed in that very same spot.
But was there groundwater table information?
Yes.
Okay, just a comment then.
It
If
was
we've
there.
got it, then we've got it.
Bill?
I have one question for Megan. The drainage that comes down off and goes towards Evergreen Drive. A while back, before that was reclaimed and repaved, we had to hold off on that until we addressed the drainage, because we couldn't keep pavement on Evergreen Drive. I just wanted to make sure that you don't see an issue with the drainage affecting Evergreen Drive?
No, I
Okay.
do not believe so. I mean, they're going, one of the things I had asked for, which should help the, get the names of the roads, is it Checkerberry first, and then it breaks off into Evergreen? We were noticing that Checkerberry was starting to break up along the edge, and it's because it
Right.
appears the water's not shutting off properly, so I think, if anything, the drainage ditch that they're proposing to install along the edge of the road should help that. The water, coming through the site, there's really not much of an increase at all. It's not like a,
Okay.
you know, it's a driveway essentially with two houses. That's the only pavement and impervious area, and that's being dealt with the 4 rain gardens, and also 2 very small, like little, detention basin areas up in the front. So I think they are doing everything they can to, you know, reduce any increase in water. I mean, the majority of the flow is just the water that comes off the mountain
Right.
through the dual culverts on, each side of Checkerberry, and that's what's sending all that water down there. I mean, it's a lot of
Okay.
water.
'Cause I wasn't here at the beginning of this, I wasn't on the board at the beginning when this project came, and I guess that's why I'm asking that question, just to make sure.
I mean, I've talked about this extensively with Carl and Mike, and neither of them had brought up that concern about
It was
down.
before their time, I hate to say.
Okay.
Don Hambidge was Public Works Director at the time.
Jim?
Well, I'm gonna defer to that side of the room, because 2 engineers and a driveway guy sitting over there to, talk about the turnaround. But if we're gonna continue this, because this has gone on a long time, I'd really like to define in a fairly narrow scope of things that are gonna come back up, because I'm fair to Mr. Todd and his applicant, we gotta move at some point on this. But what I'm hearing is driveway design, if people on that side of the room can tell us what they're looking for, or would accept or recommend, and documents. And the reason the documents, I think, is, as Collis said, and you're sort of the victim of the first time, but, we wanna see what the covenants are, because it's an important, both in its own sake and the model for going forward. So I wanna spend a little time on that. But I don't wanna, and we gotta start narrowing issues, so we don't have to readdress many things.
May I comment?
Yes.
Please review the document that I submitted regarding the maintenance of the rain gardens before we go too much further with that idea. I'd like to hear your input on the ones that have been.
And I'm gonna request that Patty send those out to us electronically, or on paper, or both, so we can take a look at them.
Okay.
Good, thank you.
Tim?
Meg, does this application fall under the requirements that the post-development off-site water be equal to or less than the pre-development as a subdivision would?
I wouldn't, generally, that should always be the case no matter what you're looking at. But in the past, when we had like a single lot subdivision or a 2-lot subdivision, we never focused on controlling off-site drainage on like a driveway in a house or 2 driveways in a house. It started to come up when we had like 3 driveways, and that's where the board had started discussing that 3 driveways or 3 lots was more of a private road, and now you'd meet public road standards, which is when I would apply all the typical rules that I would on a 17 lot. Okay, so for me, anything under 3, I don't really put in the same category. So that's why this is kind of a borderline, and Bob Todd has had some other sites where I think he had one off of the other end of Lesnick. You go down there, I think you had another single lot, and they addressed the long driveway with, again, I think a rain garden, that situation, where we wouldn't typically require specific drainage features for 1 lot, but they were doing,
Leach Hill Road it was.
you know, I think best management practices to try and control, you know, off-site flow for a single lot or now 2 lots.
Well, I ask you because we're, based on the amount of impervious surfaces on this plan, we have 2 detention areas that are, I would assume, designed to handle that runoff water from this long driveway. Is that correct?
Those 2 detention areas are taking just half the road, because the other half is sheeting off to the other side.
Which will then run directly through the culvert pipe.
Yes.
Okay.
So it's only taking half of that, that whole driveway, and then it's taking the whole circle up at the top. One of the things I had written down is actually that,
I don't in the drainage study, it wasn't in my comments, but I wrote it down to follow up with them after, is, I don't think there were any calcs, at least on the plan, on how those were, I looked at about the size of them and I saw that they were taking half of the driveway. But there's no calcs in the drainage study on those?
Yeah, we used calculations, but you're right, they're not on the plan. But
Okay.
they will be,
So,
the one you
that
get
was-
next will be.
Yeah, that's one of my comments for you, is that I need to see how you had sized those. I wasn't alarmed because it was half of a driveway, for a small stretch, but I'll double check to make sure it's sized properly for that.
Well, based on the profile, it's half of a 20-foot wide driveway, so it's still a full driveway on one side, and the other one goes back into the woods, so there's still a certain amount of water that's not being captured and detained, if you will, during big events.
I mean, the only thing we could do is potentially super elevate the whole driveway to the side and collect it all. You know,
Yeah.
if we felt as though we wanted to push that issue and make them,
I don't wanna push it right now, this is sort of food for thought for
Yep.
when we do address these types of situations and where we're going with them.
yeah.
I move that we continue this to a date that somebody can tell me, so that to permit review of the documents, particularly the maintenance agreement, and to allow the applicant, if he wishes, to propose a driveway with less pervious surface, yet providing for a turnaround that will meet whatever applicable standards there are.
Would
Am I
that-
gonna get guidance as part of that
Yeah.
motion?
I was gonna second and then ask for some specifics.
Well, I am too, but I wanted to get the thing going so we can get home today.
Did the applicant to get guidance from the planning director and
Well,
works.
but I think it's also fair to ask what we're gonna look for, so we don't surprise them again.
Okay.
Well,
I say something?
if,
You do have shared driveways, like off of Maple Ave, did that one that came off, and it's two lots they share and they split off. And then end of their driveway where you have it paved near your garage is where they, you don't, I haven't seen a shared driveway with the turnaround, the circle
Well,
in it.
Look at it this way, the driveway as proposed is wider than this room.
Yeah, that's, on a
Is it?
road I can see them doing it, but I don't look at this as road, it's driveway.
Just as a matter of fact, it's wider than this room. Tim?
I dealt with the fire department when I built my own driveway, and my driveway meets NFPA standards, and it is not this. So there are other avenues that can be discussed if you understand the standards and you propose it to the fire department and go from there. So we need to review their standards and make a suggestion to Mr. Todd so that he can, unless he wants to go on his own to see Bill, that's fine too, but
I don't think he
if
wants
you're
to
looking
do
for
that.
guidance,
And I was further gonna say is that it could be, cause Bill gets copies of these, that he's like ecstatic at the way it's designed, so he's like, I'm all set, I have no problem. Might be, could be why, if you show something different, he might be fine with that too. This is how you've shown it all along. I'm not on the first plan when you're doing more than the 3 lots, but it might be that he was fine with the design.
I would certainly entertain a motion, recommendation from the board that the applicant be in discussions with Megan and Brian as to terms.
we already have a motion on the floor,
geometry
don't we?
and whatever. Yeah, he made a motion right over
Hadn't
there.
seconded it.
Second.
Yes,
Quick comment.
discussion.
Discussion. I think Mr. Todd is looking for some direction, and sending him back into the pit of further discussions with fire and planning over the standards is doing just that. Because fire department is happy with this, we're not giving him any specific direction. There's no direction being given by this board to anyone. So, what is the standard width for a driveway, Megan?
It's a 20-foot all-weather surface, so what
No. If I'm building a house,
200.
no, that's not my question, that's a shared driveway.
Without
One house, what is the width of a driveway?
typically 10 or 12 feet.
Okay. So, all we're doing is adding one other house.
It's the length that triggers what I understand is the.
I understand that. So, Patty, Maple Ave with the shared driveway, do you have any recollection, or does anybody in this room have any recollection as to what the width of the driveway was for 2 houses?
You had 3 houses at Addison Road, it's 928 feet long and it's 16 feet wide.
Okay.
16 feet, paved
all-weather surface, which could be gravel.
Paved, and the 2-foot shoulders on each side.
Does not have to be paved, it's,
No, I know, but he's saying 16 feet wide. My understanding is that has to, it can be 20 feet of gravel. If you're gonna pave it, the minimum pavement would be 16 feet of pavement with 2-foot shoulders, which is your 20 feet. So, I mean, if you're asking us to go back into the pit and resolve this, I would go sit down, I can go sit down with Bill and tell him the maximum that the board wants to see is the 20
With
foot.
shoulders.
With shoulders, is a 20-foot all-weather surface, therefore worst-case pavement, 16 feet of pavement, 2-foot shoulders, and remove the circle and create the shortest, or, smallest turnaround possible as almost like a stub, which could be unpaved also. It could, we could just have almost like a gravel turnaround area. It doesn't have to be a paved turnaround. So it could be just although it doesn't matter anyway, it's all essentially impervious anyway. But it could be, just a gravel turnaround
Okay.
area.
You've gone way beyond from a technical standpoint, what I know, but I heard a width, I heard a shoulder, I heard no circular hammer. That all sounds like it addresses, cause I will tell you, people driving down Checkerberry Lane, under this plan, this looks like a road and people are gonna turn down it. I mean, there's absolutely no question about it. It's wider than some of the roads in this town. So, I like those parameters as set forth by Megan. I would be happy with that direction as being something that I would like to see on this plan. It also helps to address water flow. I would assume that's gonna decrease. I'm not saying we need to decrease the rain gardens, but that certainly is gonna help with water control on the site. And so I would be happy to see something like that. So
I'd
that-
amend my motion then to incorporate those provisions. 'Cause I think Mr. Todd needs some firm direction of what we're gonna accept, and the fire department needs some, so I don't, we're telling them we want less impact of this driveway, provided it meets some minimum standard, but it's leaning towards the minimum, not the maximum. Is that fair?
The idea is written on the NFPA standards, is the reason for the width is they wanna get a truck by another truck. It has nothing to do with driving a truck in and backing it out. Absolutely nothing. I've read the standards.
It is 2 houses.
Yeah.
2 houses.
I understand.
And I think it's
Yes,
600
Megan.
feet that triggers it too,
I would suggest that, I mean, we discussed this a lot. I think,
600-foot
I don't know if there's a way to
driveway.
invite Lieutenant Connor in to a planning board meeting to discuss this with him, because I've never digested the NFPA rules, except that we did add some pieces of them to our development regs under the driveway section, because I was always frustrated with, I issue driveway permits, and people would come to me and say, what are the rules? And yet I always had to run to Bill and ask what the NFPA rules are, because he always tells me it's this giant book, it's very complicated, blah, blah, blah. So I told him to pull out the necessary information that I needed. That's what has been incorporated into our development regs. I'm taking his word for it that he's pulling out the minimum, and I guess that's maybe a conversation that the planning board may wanna have with him is that truly the minimum? I've never researched the NFPA rules in depth. To me, he's giving me that information, but maybe there are lesser standards, maybe those are Goffstown Fire's, idea of what the minimum is, so maybe that conversation needs to be had, so that you can know as a board what the true minimums are, so that in these cases of just a shared driveway to 2 lots, we can truly apply the minimum requirements.
And I think that discussion needs to be had, because there's no municipal water out here, there's no fire cistern out here. Any fire that's gonna be fought is gonna be fought with a pumper truck. So we're talking about pulling hose, is what we're talking about. And do you pull hose 300 feet from the road, or you try and get and pull it from 100 feet from the road? And if you're 200 feet in, you ought to be able to back out and use Checkerberry Lane as the turnaround to get back out and away. I mean, I find this absolutely absurd.
Patty,
See, I think Mr. Todd said he developed it on the past of how he's developed the roads. And I don't think the fire department would require the circle on a shared driveway for 2 lots.
NFPA standards call for a 60-foot diameter turnaround at the end if it's over 300 feet long. It's as simple as that.
And it's not over 300 feet long.
How long is it?
Is it less than 300 feet?
I don't have the curve data here.
I don't know, how long is it?
20
No,
scale.
It's over 300. It's a 50 scale.
It's 240.
you've got in front of us
It's
is
300 feet
20
center, but I don't know what this curve is.
Oh, he's got a different plan.
Oh, he's looking at
He's looking at a different one.
Mr.
Let's just
Todd's-
move on. Let,
Well, I say it's 234 feet, but that's beside the point.
I mean, if Mr. Todd's telling us it has to be, then it has to be, I just.
It's not 600 feet, I can tell you that right now.
we need to find out what the numbers are and stop batting it
Yeah.
around tonight.
Yeah.
Let's find out what the numbers are and move on another night.
I will go back to my first comment to our new planning director. Please get a copy of the NFPA. I'm sure the town is a member of NFPA. It's available online to NFPA members.
But we don't have to have this applicant get involved in
Yeah,
that
okay.
discussion, we can do that later.
Yes, but in the future, maybe we can do something for future discussions. Now, have we given this gentleman enough information to move forward?
It's asking.
No, but I'll tell you what I'm gonna do. I'm gonna go back and I'm gonna consult other texts I have on driveways for a development with 2 homes. I'm gonna bring it back into you and I'm gonna expect it's gonna be approved.
Could you preface that with at least a meeting with our new planning director on your course of events? Please.
The Institute of, the Automobile Engineers, what's that book?
ITE.
ITE, I've got a book on my shelf that has standards for low development areas. I think that I have another planning textbook that's on my shelf that I refer to often that has standards for driveways. And if I come back with something along the lines of what I've been hearing here, I'm probably gonna be ending up, I don't wanna be sent away again, I'll be honest with you.
As before, then my recommendation, probably the board's recommendation would be gather your information, go talk to Brian, see if we can work out a game plan in conversations with Megan and Lieutenant Connor if necessary.
But we're looking for
Less
than
pavement.
if we can do that.
If we can do it. So it's a motion on the floor.
Can
Yes,
I
sir.
ask, can I ask a question? Just for Mr. Todd's benefit also. There were a couple of numbers that were put out, the 20-foot, the 16-foot pavement, a couple other things. Would it be, if he came forward with a plan that met that, I mean, would that be something that he probably would be able to leave here with an approval?
I don't think we can judge that without really seeing it.
Well, I guess because we've been trying to give him some direction. We heard some numbers. If those numbers are acceptable to all the parties that this board wants him to deal with, is that something that he should be able to get an approval?
I look at it this way. We have a planning director who is gonna coordinate this effort with the various departments and the applicant. And I would expect that the first task of our new planning person would be to advise this board as to the results of those discussions and decisions.
And I'll be willing to work with Megan on this.
But we
Yes.
have indicated that we would consider 16 feet with a turnaround acceptable.
Yes.
So I think if he's coming in with less than that, he would need to have some justification. Well, no, not necessarily. You could justify that. We're admitting our ignorance below that level, but that in our mind is, I think I'm speaking for everybody, that's no?
Not for me.
It might have to be more than that?
No, less than that.
Okay, well, I'm thinking that's the biggest that we're gonna require, but we may like less, right?
The minimum standard.
Yeah, but I don't think he has to come back with something bigger than that to make us happy. We'd be happy with something smaller.
Let me tell you where I'm coming from, Jim, okay? To me, we've always discouraged shared driveways, but we recognize in certain situations it makes sense. So the first decision we make is, does it make sense to allow a shared driveway for these 2 lots? And if we make that decision, then we design to driveway standards, not roadway standards. End of story. Simple as that.
As small as that.
All right, there were, did I hear that there was another document that needed to be done, or we just
Yeah,
didn't
the-
have it yet?
The document for the water that runs under the road.
We need an easement for the town to access the culvert that comes
Okay.
onto Lesnick
The
Road.
drainage easement
Right here.
agreement, okay.
It's shown on the plan.
So we're just incorporating a time, we need to figure the document review.
So I need to complete my motion a date that we can have this, so it's a date certain.
Date certain, yes.
I don't know when.
Mr. Chair, I was writing down dates of potential meetings in the future. The next available planning board meeting is the 22nd. I'm not sure that would allow enough time to review and.
This month?
Yeah.
Of this month.
I'll never make it.
So, the next one, I believe, is.
May 13th?
Is it May 13th?
Yeah.
They give you ample time,
Yes.
Mr. Todd?
That'll make that part of my motion.
Okay. There's a motion on the floor. Any discussion on the motion? Move the motion. All those in favor say aye.
Aye.
Those opposed? Motion carries. Chairman votes yes.
Mr. Chair, can we have our 8:30 break? I know Barbara
Oh, you were
complained.
doing so well.
I know, but I gotta.
You don't have to get up, Barbara. Yes.
I can't get up.
Motion to adjourn. Item number 3 is map 9, lot 33-7, 46 and 60. Final subdivision review hearing for a proposed 19-lot open space subdivision, Blackbriar Woods LLC. William and Elizabeth Cordes, owners. Montalona Road and Blackbrook Road, zone agricultural, continued from March 25th. The purpose of the continuation of the public hearing was to consider the yield plan. And, with that in mind, the representative of the applicant here to provide us with a presentation.
Yes.
You have the floor, Eric.
Thank you. My name is Eric Mitchell. My office prepared these plans for Blackbriar. As was stated, we're here for discussion on the yield plan. The yield plan is something that we've been before the board with a few times, and each time we come back, we're adding more information to it to give the board a better idea of what the yield actually would be or could be. The last time that we actually presented the yield plan, I don't believe we had road grades. We had the similar lot layout. We had areas of buildable areas plus 4K areas shown, but we did not have a well radii shown. What you have in the plan set is a schematic of the roadway to go from Montalona out to Blackbrook Road, and it's the same layout as what you've seen before. There's been slight modifications, but we now have the well radii, 4,000 square foot areas, and also the buildable areas shown on each lot. In addition to that, we do have profiles that we had run, and we show a template which shows the grading at a 4-to-1 grading in areas where we don't have wetlands and 2-to-1 in the areas that we do have wetlands. That plan was discussed briefly at the last meeting, the yield plan. And since then, we have received comments from staff that I'm sure you have tonight. One of the comments was that was brought up was the steepness of grade that we have in around station 38 plus 0. I'd like to point out where that is. This area through here is 38 plus 0, and you can see the grading we have going down into the over the slope here and into the wetland at a 2-to-1 slope. And this is also that's a fill, and that's a cut slope. When we initially did these, we did do them fairly quickly. We did not look at them from the standpoint of absolute best way to build it. What we've done on our, since we got the memo from the town, we've changed the profile. You can see the profile here is all the same, pretty close to the existing ground. But what has changed is in the area of station 35 plus 50 or thereabouts, this is where the grade here initially went right straight across. And that led to at least a 20 maybe 30 foot fill. What we've shown here, it's not in your paperwork, what I've shown for tonight, is we go down at a 6%, we continue down at a 1%, which alleviates the fill so that we only have about 10 feet of fill in that one area. And as we continue down the next sheet, the grade that we had here was over 9%. We still have the 8% grade. We've increased the amount of cut that we have going down, but it's not much different than what it was. About 10 feet here, up where we are going over the crest is about 15 feet. So that's one modification that we've made based on even looking at the plan and seeing that it was more than 20 feet of fill. I knew that we could adjust it to go down lower. There was questions that were raised about the floodplain down through here. Black Brook is in this area through here. The floodplain there is an unnumbered A zone, so we only have it graphically shown on our plan because that's all that the FEMA maps have. The floodplain is shown with this heavy dash line down through here, and it's on also on the northerly side of Black Brook. As you'll see, it doesn't follow a contour. This is something that's just taken off the FEMA maps and superimposed on top of what we have. Areas like here, for instance, there's a 14-foot difference in elevation from the flood line here down to the stone wall. Down in this area, it's a little bit less, so that line is general. We obviously have not done a FEMA flood study here to determine the exact elevation of where that would be. But we do know that if there's any concern whether or not a bridge across the river would have sufficient clearance for floodwaters, we can always increase the grade, put fill on Black Brook Road to raise that up, to raise up our bridge high enough so that we can have water pass underneath it. In addition to that, if we end up having to put a pier on the other side of the channel for the span, we can also have compensatory flood storage that we can actually create. Because this is a yield plan, we have not gone to the extent of actually engineering anything specific like that. With the comments that we have gotten from the board initially, we've done the grading. Based on the comments in the staff report, we've modified the grade so the fill is less around station 3550. So we still think that the yield plan is a workable plan. Obviously, there's wetland permits required if we were to go through it and try to permit it. And we do show 25 lots here. Our proposal is for 19 house lots. The 20th would be the remainder lot. So we're not asking for a 1-to-1 on every lot that we show on the yield plan. But we think the yield plan is more than just schematic. All the wetlands have been mapped on the ground, and I'd like the board to give its consideration so we can proceed ahead at a later date on the actual open space plan.
Members of the board.
I'll start.
Carlos.
Let's have good news and bad news. Bad news is I don't agree with the yield plan because I think some of these lots are not realistically buildable. For instance, lot 6. I mean, it's absolutely crisscrossed with wetlands. There's no way you could get out to the buildable portions of this without a major incursion through the Wetland Conservation District. I mean, I just don't foresee how that could possibly be built. And as far as lots 17, 18, 19, 20, and 21, I mean, you're talking about building 2,500 linear feet of roadway or so for those 5 lots with steep fills, lots of wetland impact, lots of wetland crossings and impacts. I don't think that's practicable. I don't think a developer would invest that kind of money to try and extract 5 additional lots. I don't think that's realistic. The good news is, if you take those 6 away from 25, you end up at your number that you're proposing. So, those are my comments.
Tim.
DPW's comments. I'm reading here that on page 20, on the 3rd bullet, it says much of this roadway construction is within the 100-foot wetland setback, approximately 3,570 feet of a 5,900-foot road. Do you have any comments to that, Mr. Mitchell?
The 100-foot buffer is impacted by the road to a large degree. I didn't do the math, but I'm sure it's correct, the way Public Works had done it. What we've done on the yield plan is to try to avoid direct wetland impact, which would be filling of wetlands, and also to avoid working within that 100-foot buffer. There are areas that we could be within 50 feet of the wetland. We're still in the buffer, but we'd have to have a functional values analysis done to prove that we could be within that buffer and have the board's concurrence. I agree that there's a lot of wetlands on site, but we try to show the road in configuration that would limit the amount of wetland impact and also limit the amount of buffer impact. But there is significant buffer impact, especially in the 100 feet, the 50 to 100 feet distance.
Now, you've dealt with the Conservation Commission in the past. How do you think they would react when you would ask for a waiver for 3,500 feet of road that impacts the 100-foot wetland setbacks?
I think the process would be that we would have to do a function values analysis, but the roadways are allowed, I believe, in the buffers to get access to viable uplands, if I understand it. Part of what my concern as a planner is that we're showing this yield plan to determine the number of units that can be put in a open space development. However, the yield plan like this is never allowed in your ordinance. We could never develop this in your ordinance because anything over 20 acres has to be in an open space subdivision. So at some point, this becomes, it's almost like it's unreal. I try to do what we can do to show that it is possible. Maybe turn back the clock. 15 years ago, is this the way it would have been shown? And what maybe would have happened then? But today, this would never happen. So it's easy to say, well, no, we won't let you go through that buffer because we don't think it'll work. But on the other hand, I think the applicant has the right to try to show the yield plan that has a reasonableness to it. He's not asking for all of the units. And part of the reason is we don't want to go into more wetland areas just to get extra units. So I agree the Wetlands Board, if this was, the Conservation Commission, if this was actually a good subdivision that we could bring, they'd have concerns over those impacts.
Okay, thank you.
Phil?
Not at the moment.
I'll open the hearing for public comment. Anybody wishes to speak before or relative to this project?
We agreed, I think, before that we were limiting this hearing to the yield plan only, so it perhaps ask the audience to limit their comments to that, because we don't have the revised plan in front of us.
Correct. This is a discussion of the yield plan only. Yes,
Can I come up?
you may.
Thank you.
Pull up a chair.
Where are the muffins?
I didn't have time, I worked late, and I wasn't able to bake them next time, because I have a feeling we'll be seeing a lot of each other. Next time. I'm Jackie.
sorry.
That's all right. I'm Jackie Gagnon, I live at 197 Montalona Road. And I believe my comments are about the yield plan, because that's the plan that I went and got and looked at. And I have, my first issue I want to talk about is about drainage. And I want you to have the big picture about this, not just this project, but what's been going on in the Montalona Road area in East Goffstown. We're at the top of the river valley, not the very top. You can climb to the precipice a little bit higher. There are at least 3, I should call that 4 because one of the landowners did too, heavily logged land parcels. The one you're looking at and an adjoining one, and then on Shanty Road, 2 other big parcels that have been logged very heavily. I walk that area every week, sometimes 2 or 3 times a week. There's been tremendous changes in the adjoining wetland areas here, in their growth, in the size, in the water levels that are in there. So this is an area that's very volatile. This yield plan means even more trees being cut for this road. There aren't very many left on this property, but there's going to be even more trees cut. We know that the trees hold the water in the soil, and we don't have the trees, there's more water going in to all of the brooks and all the drainage areas. A question related to that is, I'm quite sure this board, when they looked at this plan, and I know Conservation Commission, when they looked at initial plans, asked specifically to see driveway placements on this plan, and I don't see that. And you should be concerned about that. That's more impermeable surface that, you know, where is it going? Where is it sloping? That's something you need to be concerned about. My second issue is about drainage. And it's specific to this yield plan. Over the past 2 years, there's been a big increase in standing water area on all the trails on this land. And the streams that we had that you could jump over are now big areas of moving water. In fact, one of these pieces of proposed lot, I believe it's lot 14, has a, I don't know how wide it is, but you have to jump rock to get across it. It's running water. It's running down the hill. It's a small waterfall right now. You used to be able to just jump across a little brook. It's not like that anymore. So the small streams and the flows to these streams have increased tremendously in the past couple of years, along with this expansion of the wet areas and the increased water levels. So I don't think that really this yield plan, you know, obviously you're saying it's a hypothetical yield plan, and I understand that, but it's not even, I mean, it's not even a realistic hypothetical plan. And putting a bridge across that brook, it just makes me remember in 2006 going down and finding the Pollard Road Bridge gone into the Atlantic Ocean, gone. I mean, and whose responsibility is that going to be? That's going to be the town's responsibility if we lose a bridge over Black Brook. And house lots with floodplains in their backyards, I don't know, don't make sense to me. Anyway, the third area of issue I have is drainage. And it's up close and personal for me because my property is the one that stands to be the victim here. Montalona Road, heading toward my house, which is the next property adjoining in the northwesterly direction. The road slopes there, the land slopes there, and I have seen just tremendous water problems in my property since the existing house on this lot that they're talking about was built. They built the house, they tore down the barn, they ran the roads in, they did the logging operation, they deforested, and every step of the way, I have had an increase in water problems in my home. We have a very high water table there. When you go to dig footings for a deck, you only have to go down about 24 inches, and the hole fills up with water. You just pour the concrete in and mix it, and you don't have a problem with that. But between the road sloping, with water now just sliding down the road into my driveway, I have had water in my basement even in very moderate rainfalls. I have standing water in my backyard where my fire pit was built. You can't even be in the fire pit area now because you're up to your ankles in water. It was previously a dry area. I have soil erosion, like it looks like mudslides from my perennial gardens in my backyard. And the granite patio that I have around my in-ground pool has sunk an inch, and the walls of my swimming pool collapsed last year from too much water pressure. My pool man tells me it's too much water pressure from the ground pushing the walls of the pool in. The fourth issue I want to talk about is not drainage. It's roadway. Montalona Road curves and rises no matter which direction. It's curving and rising coming this way. It's curving and rising coming this way. That gives us very limited visibility to where this proposed road input is. What do you call it? Blackbriar Road, I think they're talking about. Very short distance visibility to traffic that's going to be entering. And if you're coming from the Dunbarton direction toward Manchester, November through February, give or take a couple weeks there's a further problem with sun blindness in the direction of travel coming toward Manchester, which is the direction that a school bus would be stopping in. And I spoke to the driver for the high school bus at Goffstown Truck Center, and she concurs that this is going to be a very bad place to have to stop a bus because people coming this way don't see the bus until you're just about to the edge of the property of the house. And if you're coming in this direction, you have sun in your eyes, you're not going to see that bus hardly at all. So I have a problem with that. I have a concern about that. There are some unresolved road issues on Montalona Road after they resurfaced it. Water is coming right over the berms. It must be from the slopes, and there's an ice buildup in particular. It's a little bit northwest of the entrance to this road, but it's a significant glacial proportion size ice buildup on that road that DPW has not been able to fix and talk to them. They have the road graders out there every 10 days or so in the winter to break up that ice pack that's there, so that's a problem. Building a through road like this is a real invitation to mayhem and mischief. Talk to the police department about this one, the long history of problems on this road. There's no stop sign, I don't think, on this road, certainly no speed bumps, but we've had teen drinking parties in this area. We've had motorcycle drag races, forest fires, four-wheel drive vehicles, mailbox bashing, paintball strikes, and most recently, 2 weeks ago, egging of cars in the driveway. This is an area that kids drive around in, and to have this 1 mile stretch of, woo, let's go driving through the neighborhood, I think this is not probably a good thing. I think this road is very close to the house, and it's probably better placed opposite, I think, you know, on the other side of it, but I'll let someone else speak to that. It destroys a wildlife corridor. I think that's probably not a popular thing to say these days, but it's a very heavily used wildlife corridor with herds of 20 or more deer crossing, particularly in the fall. And it destroys a lot of the beautiful stone walls that Mr. Preston built years ago with his own hands. But more importantly, from my point of view, what this yield plan does, it says to me I'm going to have a loss of value on my property. My house with its flooding basement and eroding gardens and pool collapsing, and it's going to restrict my choices on what I can do with my 14.9 acres in the future, because I'm going to have increasingly more water. I have it now. I used to have one small area of standing water, and I have multiple areas of standing water. It's going to turn my property into a wetland, and I think that's my biggest concern about this. You know, where are the driveways? Where's the water going to go? Where is the water going to go? That's my question. Thank you.
Thank you. Guest callers.
Can we ask questions?
After we hear from all the public, we can go back to it, okay?
Just continue. Encourage it to be.
Anybody else wishing to speak for or about this project? Yes, sir.
Scott Delorme, I'm the owner of the property directly across the street at 174 Montalona Road.
Could you spell your last name, please?
Sure. D-E, capital L-O-R-M-E. I know this is a discussion about the yield plan, so I'll keep it short. My only point this evening is really the intersection, which is going to come out onto Blackbrook. And so I ask that as the design is being developed, that there be some consideration to, one, the issues that Jackie brought up, not only of the sun glare and so forth during certain times of the year, but also the additional traffic now that will be entering at the apex of that corner. So where our driveway is literally directly across the street, we have 3 kids that get on the bus. So obviously that becomes a concern for us. The other is that I'm not sure what can be done from a design standpoint, but as it impacts our property going forward, the headlights that are going to be coming up and just blasting into our property doesn't do our property value any good for potential resale value in the future. So I just hope that there's potentially some conversations we can have with the new owner relative to what can be done to mitigate that as well. And again, I think what Jackie had suggested was that there are certain times of the year there's impact there with the solar glare as you're headed east. I'm not sure if that driveway the new road can be moved in either direction. I'm not sure what the wetlands will do there, but it is a consideration for safety and the number of cars. Okay, thank you.
Anyone else? Members of the board? Questions of the presenters and/or the commenters?
I have a question. Do all the houses as proposed on the yield plan meet the 100-foot wetback setback?
Careful.
I need to tell you, after my surgery, this is like a really late night for me,
This is
so
not
I'm doing pretty
Arizona.
good. It's time for Vicodin, I think. Do they usually
Careful,
have
our
a
legal
setback?
budget's getting slim.
Yeah. Yeah.
The lots do.
Okay, the lots do, as proposed, all meet that requirement.
Megan?
I may have missed this at the beginning, because you were going through some of my comments and which ones have been addressed or not. Did you comment on what, one was about the vertical curves and, that didn't meet, did you mention that you resolved that, or?
I didn't say that, but all of them can be resolved. Some are like 42, K value should have been 45. So all of those can be resolved. We did they do meet the town requirement that we did change the road, from station 35 or whatever down. But we can meet all the K values for 45.
And the horizontal curvature also, that wasn't listed on the plan?
No, it's not, but I can show that it meets with the regulations.
Let's go around here. You were asking, wanted to ask a question earlier, and I interrupted, and I apologize.
Public hearing closed now, we're done?
No, it's still open.
Well, I just want to make sure that we remain focused on the task at hand, and that is whether or not 25 lots is appropriate. I mean, eventually, we're going to get to all the other issues. The
Correct.
headlights, the intersection location, all the other issues, and those are absolutely legitimate concerns, and we'll get to those in due time. But for tonight, we're trying to figure out whether or not 25 lots is a realistic number, or should it be some other number?
Correct.
And I tried to present my thoughts on this. I think about 6 of those lots are unrealistic to think that any developer would invest the kind of money that it's gonna take, given the wetlands crossing, the length of roadway, the amount of cut and fills, that they're gonna put that kind of money into building that much roadway for 5 lots is unrealistic. So to me, those lots are, I'm sure we can show them, but the whole point of the yield plan is it realistic? And I don't think that is realistic, and certainly lot 6, which is way out in the hinterlands, across other wetlands, I don't think is realistic at all.
But the public hearing is still open?
Yes. I'm looking for comments from the board. I don't know whether we want to close the public hearing.
Well, I'm gonna request that you close the public hearing so we can act on this.
On the yield plan only?
Correct.
I
We're
have a
closing it
further
just for
question.
purposes of the yield
Just-
plan.
Okay.
Tim pointed out that in this yield plan, what sections of the road are within the wetland setback? And if you can refer to what lots they're by. And we'll start at the Montalodon Road end, okay?
I'm just gonna trace the wetland setback.
Yeah,
On here, it's a dashed line that comes in. On the 2 lots, the existing house is there, the wetland setback is right here, the 100 feet.
Right.
Right there. So the first lot is outside of the setback here, and there's the existing house there.
Okay.
On each lot that you go in, lot 25, 24, you can see that the setback is quite a ways behind the house. I believe this is 100 scale, so it's over 200 feet behind the house on 23, 24.
Okay.
On lot 2, we have the width here of at least 100 feet outside of the 100-foot buffer, so there's width there. These lots are okay. Lot 6 that I think Collis mentioned, it is a very big lot. The buildable area we have is in this area here, next to the road. As you see, if we'll go, when I get to the next sheet, this
Okay,
lot
but,
is all the way
but I think what I was it does look like you've tried to keep the lots, you know, the proposed development of the lot in the, outside of the wetland setback. But for example, the road on 6, is it fair to say that the road on 6 is, there's a wetlands crossing there, so with that whole section of the road there
Yes,
is not only wetlands, but within the setback,
Right,
obviously.
and if you look at, say, the setback that we have here versus this one,
Yeah,
it's less than 200 feet. If it was a little bit more, we would've shown a small area that's not in the setback.
okay.
So you go across one wetland, go up the hill, go through its setback, and then go right into another setback for this wetland crossing here. And that's where the things that Megan has added up, all this is in the setback down through here. we're trying to cross wetlands at 90 degrees to reduce our direct impact to the wetlands, but even coming up through here, we have a wetland here and a setback. We are close to this finger, but that's a smaller finger. We're trying to cross here, which less, so it's,
So essentially, once we hit 6, you're pretty much within the wetland setback for this road.
until you get to, well, look on the next page.
Okay.
This is still lot 6, that buildable area it's outside of the setbacks, what you have here, but that's not sufficient to put a house in, so the, excuse me, the roadway down through here.
Yeah.
In front of lots 19 and 18.
Yeah.
Is within the setback, but you see it's crossing between the two wets right here, and it's near the setback on this one. As we come down through the hill here.
When you
we
say
are,
this one, is that 17?
17,
17?
right. Once we get to about, after the last crossing, we're at about station 37, I believe. We are out of the wetland setback, because the setback is down in this area here. So we tried to stay out of that with our road coming down through here. The only place we get back into it is down near where we cross the brook. So there's a section in through here, we're out of the setback. We're out of the setback once we get up on the hill for this road too.
But you have to, essentially, you're not out of it until, it's just, I don't do good with lots of black. Okay, the road at 6 is clearly in it. Yeah, let me see yours, because I'm trying to
Do you
figure out.
want me to like pin it up there?
Yeah, that's fine, just so I can get, 'cause it just seems to me that, I know this is a yield plan and we have the argument of whether we be doing it or not, but it seems to me it would be pretty impossible to put this road in here.
The yellow is the 100-foot buffer that he was pointing out there, so, you know, this is outside of the buffer zone.
Okay.
And this is outside of the buffer zone.
Okay.
So essentially, as you said, they're back-to-back buffer zones, you know, you're into one, then you're into the other, so this whole stretch. And then when you get into here, you're essentially in the buffer of these wetlands and the
Right.
Black Brook, so.
Okay.
Does that help?
Mr. Chairman, point of order, Mr. Chairman. We have a public hearing that's open. We took comment from the public, nobody else wanted to comment. I think it's appropriate to close the public hearing, because we're discussing the merits of the yield plan now.
No, I want a clarification on where the wetlands were in regards to the road.
Yeah, I understand.
Okay.
Any more comments from the public? In reference to the yield plan only. I'll close the public hearing. Board members. My little homegrown chart. 6, 7, 8, 9, 17, and 19 are out.
Say those again, please?
6, 7, 8, 9, 17, and 19. Either for grading reasons or driveway things or steep grades from the road into the lot where the house is. Or what I believe to be topographic issues of siting a house. Similar to discussions we had on Worthley Hill Road.
So I move that on the basis of the observations and comments made by Paulus and the chair, which I'll incorporate into my motion, that we find that the maximum number of lots that would be permitted would be 19 lots, not 25. And approve a yield plan only showing that many.
I'll second that motion.
Discussion on a motion. Tim?
Well, I'm just looking at, lots, Carl and I were just looking at lots 11 and 12 as well, on the end of that little cul-de-sac on the Blackbrook end. There's a lot of fill to create that cul-de-sac. Are the driveways even gonna be feasible to those lots? Did you look at those, Alan?
Yes, I did.
Okay, you thought those were engineering?
I thought those could be possible, yes.
Okay. Didn't mean to speak for you.
I mean, I'll just, I'm trying to keep up with this, and I apologize for not being as able to bob around, but if I take the lots that Collis indicated, and I certainly have no dispute with Collis's interpretation of buildable lots and wetlands impacts, and I take those lots as noted by the chair, I would just point out that that's actually 9 lots that are on this plan in front of us that board members have raised issues in regards to their viability for a number of reasons. 6, 7.
I counted 6.
They weren't exactly the same lots that the two of them pointed out. 7, 8, 9, because that's all. Alan, what was 7, 8, and 9? What were your issues with those?
Good, I gotta go look now.
Yeah, you have
You're
to
gonna
look.
put me to task here
I
now.
am.
I gotta find them again now. Oh, it's the driveway, we got a 20-foot cut, and we're gonna get a driveway up through it.
7, 8, 9.
Huh? No, 7, 8. That was the question, 7, 8, and 9?
Yep.
It's a fill section.
Tho-
Those are the
Those are
fill
cut
sections.
sections.
Those are fill sections. Those are fill sections.
Well, the 7, 8 is a cut section.
Tell by the lines. Those are cut lines, those are filled.
I think all the other lots have an area where they can get off the road and get up into the lots with the driveways to meet the 10% grade established by the fire department. Tim?
Well, a lot of times we talk about the feasibility of the project based on the economic burden to the developer. I gotta wonder what it would cost to build a bridge across Black Brook. I mean, I don't know what a bridge costs to build, but it seems like an awful expense to build that size bridge over Black Brook.
Well, ours is not to dwell on what it costs to do something.
Well, we've talked about this in the past. If it's a yield plan we're considering, we have to decide the viability of it. And would a developer actually spend the money to build this road, to build this subdivision? We've talked about it in the past.
I don't
We
think
talked
that's-
about it on Worthley Hill in the very beginning, when they wanted to do the 30-foot rock cut for 1,400 feet.
I don't think they could build a road. It's a 100-year floodplain. Is that Army Corps of Engineer over there or not?
So, I mean, it's not just whether they can do it engineering-wise, a yield plan has to actually be feasible and viable, in my opinion.
It's the dark one.
Any other comments? But assuming there might be other lots that, this was just a blanket look at it as quickly as I've seen it. But what I'm saying is that it would be assuming that there'd be 1 or 2 that they could probably find a technical solution to that would come off my list that might go onto somebody else's list. So I think realistically,
Would we just get
somewhere around the 19 or 20
Here's my development.
range, based upon the lots as divided out here. Unless you wish to, or the board would wish to give based upon these comments, wish to give the proposer time to prove otherwise in terms of access to these lots, in terms of driveways and practical cuts and fills and those kinds of things, that we are concerned about, because the appearance of this final product has always been a concern of this board. What it looks like when it's done. We don't want the 20-foot ledge cuts. We don't want the huge fills. It's the board's purview. I'm just one member of the board.
Mr. Chair, can I ask
Yes.
a question?
Yes.
Is it my understanding, I believe it's my understanding, but I would appreciate some clarification, with approval of this plan as it is, or as you wish to do it, does this allow the developer to develop up to 19, or Does it just set a maximum and it could be less than that, or
It
what
could
is?
be- It's a maximum, and it could be less than that based upon his proposed cluster development.
And based upon future engineering plans
That is
and
correct.
what is feasible.
Yes. So it could be 19, but no more than 19. It could be 17 when it's finally done.
Okay. Thank you.
And I'll go around the room and ask if anybody has comment.
Just listen.
Corey, Carl.
I just had a question for Mr. Mitchell. Is this conventional topo or is this aerial?
This is the town's 2-foot
It's
area.
the 2-foot aerial?
Yeah, and we have agreed to accept that for yield plan
Okay.
issues in the past. Tim,
Already said my piece.
Hollis?
Well, I think, when you look at the definition of a yield plan, it talks about a plan submitted by the applicant showing a feasible, and I think that's the operative word. What's a feasible conventional subdivision plan? And when you talk about building 2,600 feet of roadway with extensive fill sections and extensive wetland crossings to access or to create 4 additional lots, I don't think that's feasible. From an economic standpoint, if nothing else, that's huge construction costs, and I can't believe that the developer can turn a profit on a lot, investing that much money, and that much roadway work, and that much permitting, and that much design, for the profit that he's gonna turn on 4 lots.
Thank you. Barbara?
I have taken the comments of Collis and our chair to heart, and I think that the number of reducing this by 6 is not enough for a number of reasons. The cut issue, the fill issues, and the practicality of access issue. As pointed out, this access off of Blackbrook Road, creating these extra lots here with that access, it's just not feasible. So, that's my position.
Bill?
I couldn't make that kind of a comment, not knowing what type of houses would be built on here, but, obviously these aren't gonna be $150,000 homes.
True. Jim?
Abstaining by my motion.
It's been so long, I forgot what it was.
Chairman, may I speak?
19 down
The hearing is
from
closed, technically speaking. The board wish to hear additional information from the applicant?
Well, we can reopen it for comment, has to be by everybody.
I'll take a motion to reopen it to take a comment from the engineer.
I'll move to reopen as long as it's brief.
Do I hear a second?
Second.
All those in favor of that motion, say aye.
Aye.
Opposed?
No.
Nay.
2 opposed. Collis and Barbara? Chair votes yes. You have 5 minutes or less.
It'll be less. Just a couple comments. With taking out certain lots, for instance, if 21 and 20 appear to be not favorable to anybody, if the lot line goes out between the two, then that's a big building lot. So you don't lose 2, you lose just 1. And the same can be said with the other lots down the road. We can continue to bring yield plans in to justify our number. We certainly don't want to be denied. We want to have the 19 units that we propose, but if the roadway was to come down through here and cross in through there, then I don't mean to go through the wetlands, but our grade would be less than what it is straight down. We'd lengthen out the slope. We could look at the piece next door at the end of Cerrientos, is that the road? About coming through and connecting to that. We can continue to come up with yield plans, and we just want to know to what extent, if it means that's how the only way we can justify the 19, that's fine, but I think that this is a practical way to do it, and just to remember that this is for the purposes of creating an open space development. The open space that would be created on this, total parcels over 140 acres when they're all put together. We're going to have at least 135 acres of open space. This entire piece here has not been cut in decades. And it has water frontage, river frontage, both on sides of Black Brook, along as the frontage of
Blackbrook Road. I think that that can't get lost in what we're trying to do. We're trying to limit our development up to the Montalona side and give all of this open space far in excess of what's required. Thank you.
Close that portion of the hearing. Move back to the motion on the floor. Any further comment on the motion? Hearing none, all those in favor of the motion say aye. Those opposed? Chair votes yes. Motion carries. Voting no was Tim and Barbara. So that the number of, as approved on the yield plan is 19. Maximum number of units, depending upon final engineering and approval by this board. Thank you.
Mr. Chairman, this was suggested, I think, in staff memo to be continued to a date certain. And I think that's to allow time for Public Works to look at the plans that were submitted for the actual open space development plans, which were submitted a month ago. And any of those dates are available, the sooner the better is good for us.
Megan? Review process, TRC, what do you think you're gonna need?
I haven't looked at it at all, I wanted to see how tonight went.
Tomorrow's okay.
Probably, I mean, you know, I'd like at least 1 month from now, not, obviously not next meeting, at least, I need at least 2 meetings out.
Okay.
And I don't know what you're expecting, I mean, that would, you know, again, that's like a round one and see where we're at, and I don't know if, I don't really like going to date uncertain where we resolve a million things and then come back and I'd definitely like to hear some comments from the board, too, on the layout.
Well, we already have a plan that's been presented showing 19 houses. Why would we postpone getting some initial input from the public and from board members pending your final review of some final engineering? As you suggest, you might want to hear what we have to say about it.
Yeah, I don't mind if that comes.
Is that kind of?
Well, it's very useful for us who don't know that much to have her comments. Otherwise, we're making comments out of ignorance, and I'd rather
Correct.
have her comments. So it's just what she's saying is they won't be at the final comments, if I understand Megan.
Yeah.
Because she needs to then take what we say, but I don't want us to see it without having her preliminary comments.
Okay.
Because my ignorance is profound in all things planning.
A month?
I need at least a month.
So if she wants at least a month, that really puts us to the 27th, because the 13th we could go to, but that really gives us 3 weeks to do a review in order to get the information out for us, and that's tight, if she hasn't started yet.
So it's 23rd of May? 27th of May?
Correct, because
Okay.
it's a big project, even though that would be my motion to continue to the 27th.
Do I hear a second on that motion, or just, any second on the motion?
I'll second.
Seconded by Phil. Any discussion on that? Tim?
No.
Board members? Move the motion. All those in favor say aye.
Aye.
Those opposed? Motion carries 7-0.
Motion to adjourn.
Thank you.
Yes,
I'd like
not
to-
quite.
I'd like to request that, in the past, Jim has suggested that, when we get into these big projects, that we pick out topics we're gonna talk about on our successive meetings, and we kinda stick to that agenda if we can do that, so we aren't all over the place all the time. I don't know if that works or not, but I know we've done that in the past to try to just zero in on something and work on it and then move on and kinda make a decision and move on rather than be all over the place. At least we get, in that light, we can possibly have an agreement on what we want for a particular part of the plan, and at least if we all agree on it, then we can move on and talk about other parts of the plan and come to a final conclusion someday.
Jim?
Yeah, I'm not Without seeing Megan's comments, there haven't been that many issues that are addressed. Typically, we do those on site plans where there's both design issues on site and there's impact off site. And certainly we've heard about the impact to the immediate abutters, but I haven't heard any engineering issues about the road. So it's premature to, in my mind, to set that schedule up now. But if Megan comes back with a list of things on top of the abutter issues, then we would do it at that time. I'm just not aware of what the issues are to set up a
Well, I don't
schedule.
necessarily mean directly related to DPW comments. I mean everything for the whole subdivision. We talk about, you know, water issues or whatever we're gonna talk about, lot sizes, you know,
We-
try to.
I think you can only get to that point after you at least have an initial presentation, you get a feel for the complexity of the project, as Jim might suggest. And there might be issues we don't even know about yet that might be brought up by a review of the plans, so.
Right behind you.
Yes, Megan?
Yeah, that's where I'm just torn, is if, you know, do you have an initial meeting for the presentation to get some of the big item issues from you guys, and then I go and do a full review or not? Like, if I remember correctly, because again, I didn't review the plan, but I remember seeing the layout. One big question I had, which, maybe if I get into, but I thought I needed input from you guys for that, has to do with the well radiuses. I believe the lots are pretty tight, and the well radiuses overlap each other, which our regs do not allow, and it's typically something we don't allow. It would, as far as I know, require a waiver of this board. That's pretty substantial for me. If the board is so inclined to allow a waiver, then, you know, I can do what we have. If you're not, then that could really change the layout. So see, for me, that's a major issue that could affect the whole design for them, I think. So I don't know if we need to get that answered, and you guys can focus on that at a soon meeting and decide that. I just hate to go do all this effort and work with them and spend their money and my time, and then you say, you look at it in 4 weeks from now, 5 weeks, and you're like, no way, we would never allow that, and then I'm like, I just feel like everybody wasted a lot of time and effort, so.
Agreed, but we have just allowed cross easement on wells up off of Till Road, just recently. They came back to the board.
Elba Drive.
Elber Drive?
Elba Drive.
Elber Drive.
That was on one lot because of the placement of the septic.
There were 3.
Septic and wells, it was 3 lots.
Oh, was it? Okay. All right, well, because this is on many of them.
So, we have in the past taken a look at it on specific conditions and made a judgment call that, because of site conditions that were.
They included waivers too. for
It
small.
included waivers,
Contamination.
yeah. So, I think it's a bridge I think we can cross when we get there, if we have to. Carlos?
Can I, if the board will indulge me, just for a couple minutes on my feasibility approach to these things? And just run through, so this is really rough math, so don't hold me to these numbers, but we're talking about trying to construct about 2,400 linear feet of roadway to build the 5 lots that are located within that 2,400 feet of roadway. If we're using $300 per linear foot of roadway construction, which is probably on the low side, given the fills and the amount of wetland impacts, that's $750,000 to build that piece of roadway, to build 5 lots. So amongst friends, let's say it's $1 million for 5 lots, that's $200,000 per lot to build that piece of roadway. Not feasible. Not feasible. It's $200,000 in roadway costs that has to get lumped on to the person who purchases the property, just for the roadway. But then they gotta buy the lot, build a house, and, you know. So, what's feasible, what's not feasible? Just a little
I know,
exercise.
yes, I understand. Yeah. Yes.
A quick comment, I mean, in follow-up to Megan's point about the well and the waivers, you know, I do think this process could be made a lot easier for staff and the public if, you know, planning didn't you know, take these plans in with waivers requests without having some direction from the board, and I know we need to deal with it on a case-by-case basis, but, you know, Megan's talking about going to TRCs and doing things before sometimes we see things where we need waivers. And I really think we need to get a handle on these plans that come in when there are waiver requests as to how we deal with it. And then my other comment would be back to Lally, which I think that we had some substantive comments tonight on the driveway issue. But the bottom line was they came here tonight expecting a final approval. I mean, that was pretty clear. Whether that was realistic or not, that's what it was on the agenda for. And we did not have final documents, they had not been approved, and we did not have final plans. And I think this board needs to direct the planning department to tell applicants that if we do not have final approved documents and final plans, that the noticed hearing will be continued, and it's their choice whether they want to come to the meeting when we announce that. And I know it's very inconvenient for abutters, but owners are paying for the professionals to come to these meetings, and butters get copies of plans, and then we end up approving these subdivisions subject to future stuff. And I think it just starts a nightmare post-approval process that we see in many other applications. So I appreciate tonight that Lally had some things that we needed to address, but I would hope that the chair will consider in discussions with planning staff as to whether that needs to be the process right away. Because as an abutter, I would rather come to the meeting and be told at the beginning, we do not have all the final documents, we're going to continue this to a date certain and go home, than to sit here to go through a discussion, a partial discussion, and still have to come back for a discussion on final things.
I think earlier today I met with our new planning director, and I committed myself to pre-meetings, having a meeting with the planning director to see what issues might be there, and to see if we can eliminate those either coming forward or at least addressing them before meetings.
Because
They come here.
I think I'm going to get to the position where if everything isn't final in front of me for final approval, I'm not gonna be inclined to approve it, because you're subject to all sorts of other people agreeing on things and abutters who haven't had an opportunity to see the final plan.
Correct. One last thing, we have the minutes from last meeting, which you didn't get a chance to read, somebody didn't.
That's what he did during the break.
Did you do that during the
Yeah, I
break?
took care of that.
I'll take a motion on the meetings of the March 25th.
I'll move to approve the minutes as passed out.
I have corrections, actually.
Motion to adjourn.
Yeah, if you look on top of page 3.
Yes.
The top line, it's waive for acceptance of items 4A, B, and C. Well, the person who made that motion, I think, was just trying to shorten it by referring to the staff write-up. But if you read the minutes by themselves, you have no idea what those are. So I think, although Gail wasn't the note taker, and somebody else who did a good job was, but just when we referred to items 4A, B, and C, they should appear in the minutes, so future generations will know what they are. So I'd request they be amended to add that. Second, on page 4, fourth paragraph down, Megan made her comments to the board concerning the drainage pipe, but I have no idea what those comments were from the minutes. They would be useful because that's the type of material comment that we would base potentially a decision on, so there should be some reference. And finally, I did ask that there be some reference to thanking Lowell for serving as the board chair, and they didn't appear, and I really like to see that in the minutes.
Can we take care of that, Madame?
Yeah, I didn't do those minutes.
Well,
I know Jessica did the minutes.
I highlighted the section.
Okay.
but
Sounds like you could probably
Please
just.
pass those in.
You can just make it up for those few places.
Make up my.
I'll amend my motion to
Think of
include.
Megan's
Sorry,
comments.
especially Megan's comments.
I'll amend my motion to include some corrections.
All those in favor say aye.
Aye.
Opposed?
Motion to adjourn.
Bill?
Just gotta give Jim an out.
I either have to sign something or somebody has to be sworn at here.
Oh, I got sworn at the paperwork just got
I signed the papers at the town clerk's office. I signed her,
I was
Oh,
sworn in
so-
last week, we just didn't do the paperwork.
see if
I have
hers
the
are in there.
paperwork here.
Are we
Okay.
standing in
I think I
adjournment?
probably have to say.
I'll take a motion to adjourn.
I
You have-
did.
He already
Second.
made a motion.
It's
All in
non-debatable,
favor?
it's already
Aye.
done.
Aye.
Thank you.
Sit next